This is the brief on crimes committed by public officers. So, we're looking at a criminal law 2 syllabus today that breaks down the Revised Penal Code, showing us exactly how government officials are held accountable and why stepping out of line is punished so severely. First, who actually counts as a public officer? Well, the law literally doesn't care about your rank, or if you're elected. Even a temporary laborer, like someone hired just to sort money orders, becomes a public officer the second they perform a public function. Think of public office like a specialized uniform. The moment you put it on to do a government task, those strict rules apply to you, regardless of your pay grade. Second, let's talk about the financial pitfalls: bribery and malversation. Bribery is accepting a gift to manipulate your official duties. But malversation, that happens when an officer misappropriates public funds. And here's the real kicker. If money is missing when demanded, the law automatically presumes malversation. You might wonder, wait, what if they didn't steal it but just lost it through negligence? Doesn't matter. Inexcusable negligence carries the exact same weight as intentional theft. Finally, we have infidelity and abuse of power. You see, the law punishes betrayals of trust way beyond just money. We're talking about a guard conniving to let a prisoner escape, hiding official documents, or an official making immoral advances towards someone desperate for help. Basically, the law treats an officer's authority like a loaded weapon, and using it to exploit the vulnerable triggers massive criminal liability. Ultimately, the Revised Penal Code guarantees that the higher the public trust placed in an individual, the heavier the legal hammer falls when that trust is broken.
When an individual enters public service, their legal reality shifts. Actions that might be simple ethical lapses for a private citizen become specialized felonies under Title VII of the Revised Penal Code. The trigger for this liability isn't a formal title or a high-ranking salary grade. Under Article 203, criminal exposure begins the moment a person takes part in the performance of public functions. That authority can stem from several sources. It can be bestowed directly by the public through popular election, granting the mandate to perform official duties. It also applies to temporary, low-level appointments. In the case of People v. Ireneo, the courts classified an emergency helper sorting money orders here at the Bureau of the Treasury as a public officer, purely based on the nature of the tasks performed. The mere assumption of a public role, regardless of rank or tenure, permanently alters an individual's legal exposure. It pulls them into the strict regulatory web of Title VII. Title VII does not treat corruption as a single, uniform offense. It operates as a highly specific taxonomy of accountability. This schematic breaks down the major fault lines of official crimes. A public officer's liability branches into distinct clusters: bribery, malversation, and infidelity. Precision in mapping the elements of an offense dictates the exact crime charged. Colloquial definitions of graft are useless in court. Prosecutors must prove each precise statutory requirement. To master Title VII, you must isolate these precise statutory elements and understand exactly where these offenses overlap. We start with direct bribery under Article 210. This offense is strictly tied to official duties. The officer must agree to execute a criminal act, an unjust non-criminal act, or refrain from their official duty in exchange for a bribe. Crucially, the offer or promise of a gift must be accepted by the officer. If they reject it, the officer commits no crime, and the person offering the bribe is charged with attempted corruption under Article 212. Indirect bribery under Article 211 lacks a specific promised act. The officer accepts a gift simply by reason of their office, anticipating a future favor. However, a mere promise is insufficient. Actual receipt and acceptance of the gift is required. At the extreme end of this spectrum lies qualified bribery under Article 211A, which carries severe penalties of reclusion perpetua or death. This charge applies exclusively to law enforcement officers. The elements are met when an arresting or prosecuting officer refrains from apprehending someone who has committed a crime, punishable by reclusion perpetua or death, in exchange for a financial benefit. The correct bribery charge is deduced entirely by examining the exact nature of the agreement. What the public officer explicitly agreed to do or refrain from doing determines the felony. For malversation under Article 217, the core element is custody. The offender must control funds by reason of their office. If funds are received without official authority, like in U.S. v. Radaza, misappropriating them is estafa, not malversation. The definition of public funds extends well beyond government tax revenues. It includes trust funds impressed with a public character. In People v. Velasquez, the courts established that misappropriating Red Cross funds triggers malversation liability because of this public character. The exact same legal reasoning applies to Boy Scout funds. They are non-governmental entities, but the funds are governed by malversation statutes. Under Article 222, private individuals can also be held liable for malversation if they take charge of public funds in any capacity, or if they conspire with an accountable public officer. The law arms prosecutors with the presumption of malversation. The mere failure of an accountable officer to produce funds upon demand creates a rebuttable presumption of misappropriation. This immediately shifts the burden of proof onto the accused to explain the shortage. Malversation is an offense of strict accountability. The nature of your custody, rather than the original source of the money, determines your liability. We arrive at the final quadrant of Title VII, infidelity in custody. These statutes protect the state's physical control over its subjects and its legal truths. Articles 223 through 225 govern the custody of prisoners, focusing on the strict duty of conveyance or charge over individuals detained by the state. The law distinguishes between connivance, which involves deliberate leniency or relaxation of imprisonment, and negligence. As demonstrated in People v. Legata, negligence here means a laxity so definite it amounts to a deliberate non-performance of duty resulting in escape. Articles 226 through 228 apply these same principles of strict custody to documents. The actus reus for this offense occurs when a public officer abstracts, destroys, or conceals a document entrusted to them by reason of their office. The courts use a strict legal definition here. A document must be complete, and it must be capable of establishing a right or extinguishing an obligation. Mere books, periodicals, or unapproved drafts do not qualify. To secure a conviction for infidelity in the custody of documents, the prosecution must prove that the removal or concealment caused actual damage to a third party or to public interest, regardless of how small that damage might be. These infidelity offenses demonstrate that the law penalizes breaches of trust over physical assets, whether human lives or legal truths, as severely as it does financial theft. The Revised Penal Code doesn't exist in a vacuum. Its framework heavily interlocks with special penal statutes. Republic Act 3019, the Anti-Graft and Corrupt Practices Act, acts as an overarching layer, expanding liability well beyond traditional penal code definitions. It penalizes acts not fully captured by bribery or malversation, such as manifest partiality, evident bad faith, or capitalizing on personal relations. Massive systemic corruption cases like plunder, under Republic Act 7080, are essentially macro crimes. They are built by stacking Title VII elements, malversation, bribery, and illegal exactions, to amass ill-gotten wealth. These elemental distinctions are what courts use to determine the line between freedom and lengthy imprisonment. In Philippine criminal law, public office is a public trust, enforced through an exacting taxonomy of strict liability and presumptions.
Title VII of the Revised Penal Code covers crimes committed by public officers. Article 203 defines a public officer as someone who takes part in the performance of public functions or duties as an employee, agent, or subordinate official in any branch of the government. The authority to perform public functions may arise from direct provision of law, popular election, or appointment by competent authority. Notably, temporary performance of public functions can also qualify an individual as a public officer for the purposes of this article. The definition of a public officer under Article 203 differs from those in special penal statutes like the Anti-Graft and Corrupt Practices Act, the Plunder Law, and the Code of Conduct and Ethical Standards for Public Officers and Employees. Moving to Chapter 2, Section 1 addresses malfeasance and misfeasance in office. Article 204 penalizes knowingly rendering an unjust judgment. The elements include the offender being a judge, rendering a judgment in a submitted case, and the judgment being unjust. A judgment is considered unjust if it is contrary to law, not supported by evidence, or both. Reasons for an unjust judgment include error, ill will or revenge, and bribery. The unjust character of the judgment must be proven and is not presumed. A key element is that the offender knows the judgment is unjust.
This requires evidence of conscious and deliberate intent to commit an injustice. An unjust judgment is distinct from a merely erroneous one, which does not serve as a basis for the charge without proof of bad faith. Article 205 covers a judgment rendered through negligence. The elements are that the offender is a judge, renders a judgment in a submitted case, and the judgment is manifestly unjust due to inexcusable negligence or ignorance. Article 206 addresses the unjust interlocutory order. The offender must be a judge and perform acts such as knowingly rendering an unjust interlocutory order, or one that is manifestly unjust through inexcusable negligence or ignorance. Article 207 penalizes malicious delay in the administration of justice. The elements are that the offender is a judge, a proceeding is pending, they delay its administration, and the delay is malicious. Malicious delay involves a deliberate intent to inflict damage on litigants. Article 208 concerns the prosecution of offenses, negligence, or tolerance. One act punished is maliciously refraining from instituting prosecution against law violators. The offender must be a public officer or officer of the law with a duty to prosecute. The officer of the law is duty-bound to prosecute. This includes officers of the prosecution department. However, internal revenue officers, when failing to report violations, are generally punishable under separate laws, not under Article 208. Dereliction of duty occurs when a public officer, knowing a crime has been committed, does not pursue the criminal's prosecution. Prosecuting officers are not obligated to file information if they are unconvinced that the evidence supports it. The commission of the crime must be proven before a conviction for dereliction. The offender must act with malice and deliberate intent to favor the violator of the law. Malice requires deliberate evil intent, distinguished from poor judgment or an honest mistake. The second act punished under Article 208 is maliciously tolerating the commission of offenses. The public officer knows a crime is about to be committed and tolerates its commission, acting with malice and deliberate intent to favor the violator. A public officer with a duty to prosecute, who harbors, conceals, or assists in the escape of an offender, is considered a principal in the crime of dereliction of duty. Article 208 is distinguished from qualified bribery under Article 211A. Article 209 addresses betrayal of trust by an attorney or solicitor. Acts penalized include causing damage to a client due to inexcusable negligence or ignorance, where client damage is essential for the crime. It also penalizes revealing a client's secrets learned professionally, where damage is not required. Furthermore, undertaking the defense of an opposing party in the same case without the first client's consent after receiving confidential information is penalized. Moving to Section 2, bribery. Article 210 penalizes direct bribery, with specific acts described. The first is a public officer agreeing to commit a crime in connection with official duties in exchange for an offer, gift, or present. Elements of this act include the offender being a public officer, accepting an offer, and accepting it with a view to committing a crime. The gift can be voluntarily offered or solicited. Acceptance of the offer or promise is sufficient. Actual receipt is not needed. The penalty corresponds to the crime agreed upon, if committed. The act the offender agreed to perform must be connected with their official duties. For example, a municipal officer releasing a prisoner for money instead of obeying a governor's order to transfer them. The act need not be a statutory duty, but part of the governmental agency's established procedure. There is no bribery if the act is a mere moral duty, or so foreign to official duties that it lacks even a color of authority. The second act penalized is accepting a gift for performing an act that is not a crime, but is connected with official duties. Key elements include the public officer accepting an offer for the execution of an act not constituting a crime. The penalty here depends on whether the officer executed the act or not. Completion requires the act to be executed. Mere agreement or promise is insufficient for accomplishment under this paragraph. A related act is when the public officer performs an unjust act connected with their duties, such as deciding a case without regard to evidence in exchange for a gift. The third act involves refraining from doing an official duty for a gift or promise. The elements of this third act include the public officer accepting a gift or promise to refrain from performing an official duty. This is illustrated by a sanitary inspector failing to report unsanitary conditions after receiving a gift. If refraining from an act constitutes a crime, the first form of bribery is committed, not the third. Finally, temporary performance of public functions is sufficient for a person to be considered a public officer. Continuing our discussions regarding direct bribery under Article 210 of the Revised Penal Code, this crime is also committed when a public officer, by refraining from an act, commits a crime, which should constitute the first form of bribery, instead of falling under the third form or direct bribery by omission. The act the offender agreed to perform must be connected with their official duties. Note that temporary performance of public functions is sufficient to constitute a person as a public officer, as seen in Maniego v. People. Article 210 of the Revised Penal Code also applies to assessors, arbitrators, commissioners, and other persons performing public duties. In bribery, a gift or present must be given to corrupt the public officer, distinguishing it from estafa. Bribery is also distinguished from prevarication. Qualified bribery under Article 211A is compared to prevarication. Under Republic Act No. 3019, the Anti-Graft and Corrupt Practices Act, receiving any gift includes accepting gifts from persons other than immediate family or relatives within the fourth civil degree of consanguinity or affinity, even during celebrations, provided the gift's value is manifestly excessive under the circumstances. Next, we discuss indirect bribery under Article 211 of the Revised Penal Code. The penalties for this offense, imprisonment or criminal penalties, are distinct from administrative penalties. The elements include the offender being a public officer who accepts gifts. Mere promise of gifts for reason of office is insufficient to constitute indirect bribery. Indirect bribery exists if there is an agreement between the public officer and the giver of the gift. The gifts are offered by reason of the offender's office, such as money received by a veterinarian for examining mules sold to the government. These gifts are usually given in anticipation of future favor. Indirect bribery has no attempted or frustrated stage. The crime is consummated if the gift is accepted. It is also distinguished from direct bribery, specifically under the second paragraph of Article 210 of the Revised Penal Code. Presidential Decree No. 46 penalizes receiving and giving gifts to public officials, even during occasions like Christmas. The prohibition includes offering parties or entertainments. Gifts under this decree must be given by reason of official position, and it is immaterial whether the gift is for past favors or future benefits. PD 46 prescribes a specific penalty for its violation. We now examine qualified bribery under Article 211A of the Revised Penal Code, as incorporated by Republic Act No. 7659. The penalty for an unprosecuted offense is reclusion perpetua and/or death. The death penalty applies when the public officer asks for or demands the gift or present. The elements require the accused to be a public officer entrusted with law enforcement, such as an arresting or prosecuting officer. Qualified bribery also requires that the offender not arrested or prosecuted committed a crime punishable by reclusion perpetua and/or death. The accused refrained from arresting or prosecuting the offender in consideration of an offer, promise, gift, or present. Qualified bribery under Article 211A is distinguished from prevarication under Article 208 and compared to direct bribery involving a criminal omission under Article 210. Corruption of public officials under Article 212 of the Revised Penal Code imposes the same penalties as those upon the public officer corrupted. The elements of this crime are that the offender makes offers, promises, or gives gifts or presents to a public officer. In this offense, the offender is the giver of the gift or offerer of the promise. The offers, promises, or gifts must be given under circumstances that would make the public officer liable for direct or indirect bribery. Presidential Decree No. 749 grants immunity from prosecution to givers of bribes and their accomplices in graft cases. The requisites for immunity include voluntary information relating to violations of specific legal provisions, including Articles 210, 211, and 212 of the Revised Penal Code, Republic Act No. 3019, and the National Internal Revenue Code. Additional laws covered include the Tariff and Customs Code and other provisions penalizing abuse or dishonesty by public officers. Further requisites for immunity are the willingness to testify against the public official and the concurrence of additional conditions. The information must refer to consummated violations of specified provisions of law, rules, or regulations. Other requisites for immunity are that the information and testimony are necessary for conviction and are not yet in the state's possession. They must also be corroborated in material points. The informant or witness must not have been previously convicted of a crime involving moral turpitude. The scope of immunity is exemption from prosecution or punishment for the offense to which the information or testimony pertains. The giving of such information may be pleaded as a bar to prosecution. Immunity from prosecution may be pleaded even against non-public officials who are principals, accomplices, or accessories. Immunity is available even if the informant offered or gave the bribe. However, immunity does not attach if the information is false and malicious. A false informant may be liable to civil or criminal action by the denounced public officer. Finally, we discuss Section 4 of Republic Act No. 3019, which contains prohibitions specifically applicable to private individuals, including penalties. Prohibited acts involve capitalizing, exploiting, or taking advantage of family or close personal relations with public officials, and inducing or causing public officials to commit corrupt practices. We begin with frauds against the public treasury and similar offenses under Article 213 of the Revised Penal Code. This article covers the penalty and specific acts penalized, such as frauds against the public treasury, involving agreements to defraud the government regarding supplies, contracts, or account adjustments related to public property or funds. The elements of this offense include the offender being a public officer who takes advantage of their office by intervening in the transaction in an official capacity. Acting in an official capacity involves dealing with persons concerning furnishing supplies, making contracts, or adjusting public property or funds accounts. A third element is the offender entering into an agreement with an interested party or speculator, or using other schemes to defraud the government concerning supplies, contracts, or account settlements. The outcome of the fraud is irrelevant. Finally, the offender must have intended to defraud the government. The crime also includes illegal exactions by demanding payments different from or larger than legally authorized. An element of this is the offender being a public officer, entrusted with collecting taxes, licenses, fees, and other imposts. Article 213 applies to a deputy sheriff but not to officers or employees of the Bureau of Revenue or Customs, who are covered by other codes. Another element is the offender directly or indirectly demanding payment of a sum of money, with the mere demand for a larger or different amount sufficient to consummate the crime. If the larger sum is further spent, malversation is also committed. The demanded sum must be different from or larger than that authorized by law. We continue our discussions relative to frauds against the public treasury and similar offenses under Article 213 of the Revised Penal Code. Specifically, we look at the crime of illegal exactions by failing to issue receipts for sums officially collected. The key elements include a public officer entrusted with collecting public funds who voluntarily fails to issue a receipt as required by law. We continue with illegal exactions under Article 213, focusing on collecting things or objects different from those legally provided. The elements are: the offender is a public officer entrusted with collecting taxes, licenses, fees, or other imposts. They collected or received, directly or indirectly, things or objects, and these objects are of a nature different from what the law provides. Next, we examine other frauds under Article 214 of the Revised Penal Code, which specifies penalties additional to those provided for other crimes. One element is that the offender must be a public officer. Also, the offender must take advantage of their official position, as seen in cases where the additional penalties of Article 214 are applied to a counselor. Another element for other frauds is that the offender must commit any of the frauds or deceits enumerated in Articles 315, 316, 317, and 318 of the Revised Penal Code. These include swindling, other forms of swindling, swindling of a minor, and other deceits. Moving to prohibited transactions under Article 215, we address the penalty and elements. The first element is that the offender is an appointive public officer. The second is that the offender becomes interested, directly or indirectly, in transactions of exchange or speculation, which includes buying and selling stocks or land in hope of exploiting price fluctuations. We continue discussing prohibited transactions. Purchasing stock or shares alone is merely investment and does not violate Article 215. However, regularly buying securities for resale is considered speculation. Additionally, the transaction must occur within the territory subject to the offender's jurisdiction, and the offender must become interested during their incumbency. Our next topic is possession of prohibited interest by a public officer under Article 216. This article outlines the penalty and specifies the persons liable. These include public officers who, directly or indirectly, become interested in contracts or business in which they officially intervene. The first element is simply that the offender is a public officer. The second element for possession of prohibited interest is that the offender becomes interested, directly or indirectly, in certain contracts or business. Actual fraud is not necessary. The mere possibility of fraud or preference of personal interest to those of the government is sufficient. The third element is that it must be the offender's official duty to intervene in such contracts or business. Article 216 also applies to experts, arbitrators, and private accountants who take part in contracts or transactions related to property they appraised, distributed, or adjudicated. The elements include the offender's role as an expert, arbitrator, or accountant, their participation in the contract or transaction, and their previous role in the appraisal, distribution, or adjudication of the property. Lastly, Article 216 applies to guardians and executors concerning property belonging to their wards or estate. The elements are: the offender is a guardian or executor, and they become interested, directly or indirectly, in the property belonging to the ward or estate. Article 216 relates to constitutional provisions that prohibit financial, business, or professional interests for senators, members of the House of Representatives, the President, Vice President, cabinet members, and members of constitutional commissions. We now address malversation of public funds or property and the presumption of malversation under Article 217. Penalties depend on the amount involved in the misappropriation. Importantly, the penalty for malversation remains the same, whether committed with malice, negligence, or imprudence, with an exception for rules providing lower penalties for criminal negligence. Article 217 punishes several acts as malversation: appropriating public funds or property, taking or misappropriating public funds, consenting or permitting through abandonment or negligence any other person to take public funds or property, or being otherwise guilty of misappropriation or malversation. The common elements of malversation under Article 217 start with the offender being a public officer. The nature of the duties, not the name of the office, is controlling. Private individuals, however, may also be held guilty of malversation if acting in conspiracy with public officers. The second common element is that the offender must have custody or control of funds or property by reason of the duties of their office. If funds are not received in an official capacity, the crime committed is estafa, not malversation. The third element is that the funds or property were public funds or property for which the officer was accountable. However, an officer with only qualified charge of property, without authority to part with physical possession, generally cannot incur liability for malversation unless upon order from a superior. Government funds include revenues and trust funds, such as Red Cross and Boy Scout funds. Funds like NARIC and Metropolitan Water District funds, though not strictly public, are impressed with public character when entrusted to accountable public officers. Public property includes items like firearms and explosives seized from unauthorized possessors or materials of the Bureau of Commerce and Industry. Funds represented by a drawn and endorsed check become private property, so non-delivery of the money is estafa, not malversation. However, private funds in the custody of accountable public officers may still lead to malversation under Article 222. The fourth element is that the offender committed prohibited acts, such as appropriating, taking, or misappropriating public funds or property. Taking in malversation has the same meaning as in theft. The property taken does not necessarily need to be misappropriated. The prohibited acts also include consenting to another person taking such funds or property, often through abandonment or negligence. Negligence must be positively and clearly shown to be inexcusable, approximating malice or fraud. Simple negligence or criminal abandonment may only lead to civil accountability if the transaction was made for valuable consideration. The measure of negligence is the standard of care commensurate with the occasion. For example, entrusting large sums of money to a mere driver is considered proof of negligence and abandonment. Permitting, through abandonment or negligence, another to take public funds or property is also a prohibited act. Lack of criminal intent or good faith are defenses in malversation, not committed through negligence. Presumption of malversation arises upon failure to have public funds or property forthcoming upon demand. Conviction can occur without direct evidence of misappropriation if there is an unexplained shortage, but this presumption is rebuttable, and the burden of defense rests upon the accused. The return of malversed funds is only a mitigating circumstance, not an exempting one, and requires prompt refund. However, there is no liability for malversation if the shortage is paid by the public officer the moment it is discovered, establishing no prima facie evidence of crime. A person whose negligence led to malversation may be held as a principal by indispensable cooperation in complex crimes, such as falsification of public documents by reckless negligence. Damage to the government is not a necessary element of malversation. Furthermore, laws like the Comprehensive Dangerous Drugs Act penalize apprehending officers who misappropriate seized drugs or property. It is important to distinguish malversation as defined under Article 217 of the Revised Penal Code from malversation as a means of accumulating ill-gotten wealth in the crime of plunder under Republic Act No. 7080. Next, we discuss the failure of an accountable officer to render accounts under Article 218. The elements are: the offender is a public officer accountable for public funds or property, required by law or regulation to render accounts, and failed to render accounts for 2 months after they should have been rendered. Demand for accounting is not necessary. Misappropriation is not necessary for a violation of Article 218. However, if there is also misappropriation, additional liability under Article 217 for malversation applies. The law punishes the failure to render accounts to enforce the duty of public officers to account for government funds. Article 219 covers the failure of a responsible public officer to render account before leaving the country. The elements include the offender being an accountable public officer who unlawfully leaves or is about to leave the Philippines without a certificate from the Commission on Audit showing final settlement of accounts. This crime can be related to violations of anti-graft laws regarding the filing of statements of assets and liabilities. The offense of illegal use of public funds or property, known as technical malversation, is found in Article 220. The elements are: the offender is a public officer, there are public funds or property under their administration appropriated by law or ordinance, and the officer applies the funds or property to a public use other than the one appropriated for. The essence of this crime is the violation of the specific appropriation for a particular public purpose. This type of malversation is distinguished from the malversation defined under Article 217, as the illegal use still involves application to a public use, albeit one for which the funds were not intended. We begin with the crime of failure to make delivery of public funds or property under Article 221. This article outlines the penalty and the specific acts penalized. One key act is the failure to make payment by a public officer who is obligated to do so from government funds in their possession. The second act penalized by Article 221 is the refusal to make delivery by a public officer when ordered by competent authority to deliver property in their custody or under their administration. Key elements include the public officer's possession of government property, an order for delivery from a competent authority, and a malicious refusal to comply with that order. Article 222 addresses officers included in the preceding provisions, extending liability to certain private individuals. This includes private individuals who, in any capacity, have charge of national, provincial, or municipal funds, revenue, or property. Article 222 also extends liability to administrators or depositories of funds or property attached, seized, or deposited by public authority, even if such property belongs to private individuals. For instance, sheriffs and receivers are included under the term administrator for this purpose. We now move to infidelity of public officers, starting with conniving with or consenting to evasion under Article 223. This falls under infidelity in the custody of prisoners. The elements include the offender being a public officer, having custody of a prisoner, either a detention or a sentenced prisoner, and the prisoner escaping from custody. A crucial element of conniving with or consenting to evasion is that the offender was in connivance with the prisoner in the latter's escape. This presupposes knowledge of the prisoner's intention to escape. Notably, relaxation of imprisonment, such as allowing a prisoner to stay in a guard's house, is considered infidelity. Next is evasion through negligence, under Article 224, also part of infidelity in the custody of prisoners. The penalty is the same regardless of whether the escapee is a detention prisoner or sentenced by final judgment. The elements include the offender being a public officer charged with the conveyance or custody of the prisoner. A key element for evasion through negligence is that the prisoner escapes through the offender's negligence. This negligence must be a definite laxity that amounts to a deliberate non-performance of duty, as demonstrated in cases where a guard falls asleep or leaves a prisoner unattended. Mistake or distraction that does not amount to evasion through negligence may still be subject to administrative action. It is important to note that the recapture of an escaped prisoner does not afford complete exculpation from liability under this article. Liability of the escaping prisoner is governed by Article 157. Article 225 addresses the escape of a prisoner under the custody of a person not a public officer. The penalty for a private person liable under this article is 1 degree lower than that prescribed for a public officer under Article 223 or 224. The first element is that the offender is a private person. Other elements for the escape of a prisoner under the custody of a person not a public officer are that the conveyance or custody of a prisoner or person under arrest is entrusted to the private person, and the prisoner or person under arrest escapes. This happens because the offender consents to the escape, or the escape takes place through the offender's negligence. This video covers the crime of removal, concealment, or destruction of documents under Article 226 of the Revised Penal Code. The penalty depends on the seriousness of damage to public interest. The elements of the crime include the offender being a public officer, and the offender abstracting, destroying, or concealing documents or papers. It's important to note that books, pamphlets, and periodicals are not considered documents for this crime. However, the term papers includes checks, promissory notes, and paper money. Infidelity in the custody of documents can occur through the opening of a letter containing money or retaining mail without forwarding it. The reason for penalizing infidelity in the custody of documents is the real and positive injury to public service and public interest. Article 226 applies if the offender is an employee of the Bureau of Posts. Money bills received as evidence in court are also considered papers. The acts punished are removal, destruction, or concealment of documents or papers. The act of removal need not be coupled with concealment, as removal, destruction, or concealment are distinct modes of committing the offense. Removal must be for an illicit purpose, or coupled with criminal intent. However, infidelity in custody by destroying or concealing does not require proof of illicit purpose. Removal is considered consummated upon removal from the usual place. Delivery of a document to the wrong party constitutes infidelity in custody. The documents or papers must have been entrusted to the public officer by reason of their office. Only public officers officially entrusted with custody can be held liable under Article 226. Damage, whether serious or not, is required. The video distinguishes this crime from malversation and falsification. Now, let's discuss the crime of officer breaking seal under Article 227 of the Revised Penal Code, including the penalties. The elements are: the offender is a public officer, charged with the custody of papers or property which are sealed by proper authority, and the offender breaks the seals or permits them to be broken. Breaking of seals is punished, not merely opening a closed envelope. Damage or intent to cause damage is not necessary. We move on to the crime of opening of closed documents under Article 228 of the Revised Penal Code and its penalties. The elements are: the offender is a public officer. Any closed papers, documents, or objects are entrusted to their custody, and the accused must actually become the custodian of the closed documents. The remaining elements are: the offender opens or permits the closed papers, documents, or objects to be opened. This act should not fall under Article 227. Also, the offender does not have proper authority to open them. Damage or intent to cause damage is not an element of opening closed documents. The next crime is revelation of secrets by an officer under Article 229 of the Revised Penal Code and its penalties. One act punished is revealing secrets known to the public officer by reason of their official capacity. The elements for this include the offender being a public officer, knowing a secret due to their official capacity, and the secret affecting public interest, not private persons. Continuing with the elements for revealing secrets, the offender reveals such secret without authority or justifiable reasons, and damage, great or small, has been caused to public interest by the revelation. Damage is an element of this offense. The second act punished is wrongfully delivering papers or copies of papers which should not be published. For the second mode of revelation of secrets, the elements are: the offender is a public officer, has charge of papers, which means control and custody. These papers should not be published. The offender delivers those papers or copies to a third person, which is wrongful, and damage has been caused to public interest. Damage is an element of this offense. The second mode of revelation of secrets is distinguished from infidelity in the custody of documents or papers by removing them. Article 229 does not contemplate espionage. It punishes minor official betrayals. The video also distinguishes this crime from violations of Republic Act 3019 and Republic Act 6713 concerning confidential information. Next, we examine the crime of public officer revealing secrets of private individuals under Article 230 of the Revised Penal Code. This includes the penalty. The elements are: the offender is a public officer and knows of secrets of a private individual by reason of their office. Note that Article 230 does not apply if the offender is an attorney. The final elements of Article 230 are: the offender reveals such secrets without authority or justifiable reason. Revelation to one person is sufficient. Public revelation is not required. Damage to the private individual is not necessary, as the law's purpose is to uphold faith and trust in public service. We now address the crime of open disobedience under Article 231 of the Revised Penal Code and its penalties. The elements are: the offender is a judicial or executive officer. There is a judgment, decision, or order of a superior authority, which was made within the scope of jurisdiction and issued with all legal formalities. The offender openly refuses to execute it without any legal justification. The next offense is disobedience to order of superior officer, when said order was suspended by inferior officer under Article 232. The penalty is prescribed in this article. The elements are: the offender is a public officer, an order is issued by the offender's superior for execution, and the offender has suspended the execution of the order for any reason. Continuing with the elements of Article 232, the superior must disapprove the suspension of the order's execution, and the offender disobeys the superior despite the disapproval. The reason for this provision is to prevent an inferior officer from dictating to their superior through resistance. Article 232 does not apply if the superior's order is illegal. Next, we cover refusal of assistance under Article 233. This article outlines the penalties. The elements include: the offender is a public officer. Competent authority demands cooperation for the administration of justice or public service, and the offender maliciously fails to cooperate. The final element for refusal of assistance is that there is damage to public interest. If the damage to public interest is serious, the penalty is higher. If not serious, the penalty is lower. This is an obligation arising from the election by will of the people. The crime of abuses against chastity under Article 245 is committed when a public officer solicits or makes immoral advances to a woman. Soliciting means proposing earnestly and persistently something unchaste or immoral. Proof of solicitation is unnecessary if sexual intercourse occurred, and the advances must be immoral or indecent. Moving on to maltreatment of prisoners under Article 235. The penalties are specified here. The elements are: the offender is a public officer or employee and has custody of a prisoner or detention prisoner. Actual charge is essential for criminal liability. The remaining element is that the offender maltreats the prisoner in a manner specified in Article 235. This includes overdoing correction or handling, imposing unauthorized punishment, or inflicting authorized punishment in a cruel and humiliating manner. Maltreating prisoners to extort a confession or information is also penalized. Liability for physical injuries or damage caused is separate from that arising under Article 235. The video also notes related legislation such as RA 7438 and RA 9745. Republic Act 7438 defines the rights of arrested or detained persons and the duties of arresting officers. Republic Act 9745 penalizes physical and psychological torture, as well as cruel, inhuman, and degrading treatment or punishment. The next offense is anticipation of duties of public office under Article 236. The elements are: the offender is entitled to the office, but law requires being sworn in or giving a bond first. The offender assumes the duties before taking the oath or giving the bond. Article 236 does not apply to appointive officers. Next, we cover prolonging performance of duties and powers under Article 237. The elements are: the offender is a public officer, the period for holding office has expired, and the offender continues to exercise the duties and powers of the office. This also applies to officers who have been suspended, separated, or dismissed. We now examine abandonment of office under Article 238 and its penalties. It is qualified if the abandonment is to evade duties of preventing, prosecuting, or punishing crimes. The elements are: the offender is a public officer and formally resigns from their position. Further elements of abandonment of office are that the resignation has not been accepted, and the offender abandons the office to the detriment of public service. Written or formal resignation is required. This crime is distinct from negligence in the prosecution of offenses. The crime of usurpation of legislative powers under Article 239 applies to executive or judicial officers. The elements include the offender making general rules or regulations beyond authority, attempting to repeal a law, or suspending the execution of a law. Finally, we discuss usurpation of executive functions under Article 240. This offense applies to a judge who assumes powers pertaining to executive authorities or obstructs executive authorities in their functions. Legislative officers are not liable under this article. We begin with usurpation of judicial functions under Article 241 of the Revised Penal Code. This crime is committed by an officer of the executive branch who assumes judicial powers or obstructs the execution of a judicial order or decision. Next is disobeying request for disqualification under Article 242. This occurs when a public officer continues a proceeding despite a pending question regarding their jurisdiction and being lawfully required to refrain from continuing. We move to orders or requests by executive officers to any judicial authority under Article 243. The offense is committed by an executive officer who addresses an order or suggestion to a judicial authority regarding a case within the court's exclusive jurisdiction. The purpose of this provision is to maintain the independence of the judiciary. Article 244 addresses unlawful appointments. The elements include a public officer nominating or appointing a person to public office, and the offense is committed by the act of nominating or appointing itself. Continuing with unlawful appointments, the person nominated or appointed must lack the legal qualification for the office, and the offender must know of this lack of qualifications at the time of the nomination or appointment. The crime of abuses against chastity under Article 245 penalizes soliciting or making immoral advances to a woman interested in matters pending before the officer, or a woman under the officer's custody, or a relative of a person under the officer's custody. For abuses against chastity, the woman must fall under one of the three enumerated classes in Article 245. The crime is consummated by the mere proposal of immoral or indecent advances. Welcome to this video on Title VII, the Blueprint of Public Accountability. We will explore a visual taxonomy of crimes committed by public officers under the Revised Penal Code of the Philippines, focusing on synthesized elements, distinctions, and jurisprudence. Who bears the public trust? Public officers include core government executives, agents, and employees. They are defined by the RPC and special laws, encompassing those appointed by competent authority, or those performing public functions temporarily, such as in the Maniego versus People case. We examine the blueprint of accountability regarding a breach of duty or omissions in the justice system. This involves unjust judgments rendered knowingly or through inexcusable negligence by a judge. It also covers prosecutors or law officers who maliciously refrain from prosecuting or tolerate crimes commission. The corruption of office involves the bribery spectrum, ranging from direct and indirect bribery by public officers to qualified bribery by law enforcement and corruption by private individuals. Each is distinguished by the offender, the act, the consideration, and the stage of execution. Direct bribery has three paths of culpability: performing a crime, performing an unjust act, or refraining from duty. Presidential Decree No. 46 strictly prohibits public officers from receiving gifts by reason of their official position. Article 213 covers frauds and illegal exactions. Frauds against the Treasury occur when a public officer intervenes in an official capacity to defraud the government. Illegal exactions involve demanding unauthorized payments, failing to issue official receipts, or receiving unauthorized objects. The conflict of office addresses prohibited interests. Prohibited transactions apply to appointive officers interested in speculation within their jurisdiction. Possession of prohibited interest applies to those, like public officers or executors, interested in contracts where they have a duty to intervene. The anatomy of malversation, under Article 217, requires a public officer to have custody of public funds or property and misappropriate them. The legal presumption, or tipping point, is the failure to duly present public funds or property upon demand. Boundaries of malversation include situations where a lack of control leads to theft or estafa, not malversation. The nature of duties controls determines accountability based on authority, not specific performance. Private individuals can also be liable if they conspire with accountable officers. Technical malversation, Article 220, involves the illegal use of public funds. This occurs when legally appropriated public funds are applied to a different public use. Unlike malversation, the offender usually derives no personal gain, and the funds are used for a public purpose, albeit the wrong one. Breach of custody Part 1 focuses on the evasion of prisoners. This can be through connivance, where a public officer consents to the escape, negligence, which is definite laxity, or private custodian, where a private person allows the escape. Breach of custody Part 2 covers documents and seals. The object must be a document or paper. The offense includes removal, destruction, or concealment, breaking seals, or opening closed documents without authority. The resulting requirements for damage vary between articles. Breach of custody Part 3 addresses the revelation of secrets. For secrets of the state, damage to public interest must be caused. For secrets of private individuals, damage is not necessary. The law punishes the breach of faith in public service. The abuse of power includes usurpation of powers, where branches of government exceed their authority. Maltreatment of prisoners involves imposing unauthorized or cruel punishment. Abuses against chastity relate to soliciting or making immoral advances toward specific individuals. The ecosystem of accountability includes the Revised Penal Code, which provides the granular elements of corruption. The graft law expands this, penalizing private individuals and defining corrupt practices. The plunder law addresses patterns of malversation and bribery amassing substantial wealth. The informant's shield grants immunity to those who testify.
Welcome to this explainer. I am absolutely thrilled you're joining me today because, well, we're tackling something incredibly vital. We're looking at a pretty dense, comprehensive criminal law syllabus specifically focusing on crimes committed by public officers. Now, I know legal syllabi can look super intimidating, but think of this as an accessible, empowering guide. This is literally the ultimate rulebook for how the law holds government officials accountable. Okay, let's dive into this. Have you ever wondered what exactly happens when the very people we trust to uphold the law break it? You know, when the guardians of our system just turn their backs on their duty? The societal impact is massive. It's this profound betrayal of public trust that ripples through every single level of a community. So today we're going to unpack the exact legal mechanisms designed to define and punish that betrayal. To make sense of this massive web of laws, we're going to break it down into 5 distinct buckets. First up, defining the public officer. Second, failing the duty of justice. Third, the mechanics of bribery. Fourth, plundering the public purse. And finally, infidelity and abuse. Starting with Section 1, defining the public officer. Who exactly holds the public trust? Before we can even talk about the crimes they might commit, we absolutely must establish who these laws apply to. And honestly, you might be surprised by how broad this net actually is. According to Article 203 of the Revised Penal Code, a public officer is anyone taking part in the performance of public functions in the government or performing public duties as an employee, agent, or subordinate official. So the crucial point here is that rank or class is completely immaterial. The syllabus explicitly notes that even a temporary laborer, if they're performing a public function, like say sorting and filing government money orders, they become a public officer under the law. It's about having a fancy title. Actually, scratch that. It's completely the opposite. It's entirely about the function you perform. Moving on to Section 2, failing the duty of justice. What happens when the courts and police fail us? Here we're focusing on the malfeasance committed by those directly responsible for administering justice. We're talking judges, prosecutors, and police officers. And this brilliantly illustrates a critical distinction in the law regarding judges. On one side, we have an unjust judgment. This is when a judge renders a decision contrary to law or completely unsupported by evidence, but specifically driven by ill will, revenge, or bribery. On the other side, we have an erroneous judgment. This is a judgment made in good faith that just happens to be a legal error. The law totally recognizes honest human error. There's no criminal liability for just making a mistake.
For a crime to actually occur, bad faith and a conscious, deliberate intent to do an injustice must be proven.
But judges aren't the only ones accountable, right? Article 208 covers dereliction of duty for officers of the law. This happens when an officer maliciously refrains from prosecuting violators or maliciously tolerates the commission of offenses. Imagine if a local police chief knows all about an illegal gambling ring, like a jewel-ting operation, and deliberately ignores it. That chief is committing a crime simply by looking the other way. The deliberate intent to favor the criminal is exactly what seals the charge.
That takes us to Section 3, the mechanics of bribery. Let's unpack the price of corruption. We really need to dissect the highly nuanced ways bribery is classified under the law. As you'll see, it's not always just about handing over a bag of cash in a dark alley. We have direct bribery versus indirect bribery. Direct bribery, under Article 210, is a clear transactional agreement. A public officer accepts a gift or promise specifically in exchange for performing an unjust act or for refraining from doing their official duty. Imagine taking cash specifically to drop a valid traffic ticket. That's direct. Indirect bribery, under Article 211, is a bit more insidious. It's accepting a gift offered simply by reason of the office held. Imagine accepting a lavish holiday basket just because you are the mayor. There's no specific favor asked for right then and there, but the gift is given in anticipation of a future favor. Now, what's really fascinating here is the flip side of the transaction. The giver of a bribe is also guilty of a crime called corruption of public officials. However, the syllabus points out Presidential Decree 749, which smartly provides a step-by-step path to immunity for the bribe giver. Why? To encourage whistleblowers. If you voluntarily give information about the bribe, ensure it's necessary for conviction and unknown to the state, willingly testify, and have no previous convictions for moral turpitude, you can actually be granted immunity. It's a strategic legal tool designed to break these hidden networks of corruption. Section 4, plundering the public purse, protecting the treasury from greed. We are now focusing on the theft and mismanagement of government funds and property. The centerpiece here is malversation under Article 217. The elements are quite straightforward. You must be a public officer, you must have custody of funds or property because of your office, those funds must be public, and you appropriate or take them. So, the crucial point is this. You don't even have to steal the money yourself to be guilty. No way. The law clearly states that if you permit someone else to take the funds through your own inexcusable negligence or abandonment, you are equally liable for malversation. And the law gives auditors and prosecutors a very powerful tool here, a legal presumption of guilt. If an auditor demands the public funds or property that you are supposed to be holding and you cannot produce it, that failure immediately creates a legal presumption of malversation. The burden of proof shifts entirely to the accused public officer. If they can't satisfactorily explain the shortage, a conviction can follow, even without direct evidence of them physically pocketing the cash.
Beyond malversation, there are other ways the public purse is plundered, captured under frauds and illegal exactions in Article 213. This includes entering into agreements with contractors specifically to defraud the government. It also covers illegal exactions, like a tax collector demanding payments larger than legally authorized. And definitely pay attention to this crucial detail, voluntarily failing to issue official receipts for collections. Even just failing to issue a receipt for a collected fee is a criminal act, because it deliberately breaks the paper trail of public money.
Finally, Section 5, infidelity and abuse, breaking the chain of custody and trust. Public officers are entrusted with much more than just money, right? They handle physical human beings, vital documents, and highly sensitive information. Now, what's really interesting about this is how meticulously the law categorizes the different ways an officer can mishandle what we entrust to them. For instance, under custody of prisoners, a guard commits infidelity if they connive to let a prisoner escape, or even if they lose them through sheer negligence, like leaving a post to run an errand. Under custody of documents, a public officer commits a crime by abstracting, destroying, or concealing official papers or mail to cause public damage. And under revelation of secrets, an officer can be penalized for divulging confidential information they only know because of their office, thereby damaging the public interest. To round out the syllabus, we see a final catch-all of abuses that directly violate the public's mandate. Article 235 penalizes the maltreatment of prisoners, inflicting unauthorized, cruel punishments or extorting confessions. Then there's abandonment of office. You literally cannot just walk away from a public post before a formal resignation is officially accepted if it detrimentally affects public service. And finally, usurpation of powers. This is when an executive officer oversteps their boundaries and acts like a judge, or vice versa. It's a strict protection of the balance of power. You have to stay in your lane. All of these specific articles we've covered, from bribery to malversation to infidelity, they all boil down to the single, powerful constitutional principle. Public office is a public trust. These dense, complex penal codes we've just explored are ultimately just the enforcement mechanism for this one central idea. It means every action a public official takes must be for the people, not for themselves. Which brings us to our final thought. Knowing the strict elements of these crimes, how robust is the oversight of public officers in your own community? Now that you understand the legal anatomy of betrayal, you have a new, empowering legal lens to view local and national governments. Keep asking questions, keep demanding accountability, and keep learning. Thanks for joining me on this explainer.
Imagine you're a judge, right? You're presiding over this really contentious legal dispute.
Okay, setting the scene.
Yeah. And a man walks into your courtroom, but he completely ignores all the evidence being presented.
Just walks right past the lawyers.
Totally ignores them. Instead, he simply walks up to the bench, hands you the lead rope to a live female water buffalo, and just asks for a favorable verdict.
A water buffalo.
A carabao.
Literal carabao, right there in the courtroom. So the question is, do you take the carabao and throw the case?
I mean, it sounds completely absurd, right? Almost like some kind of weird legal fable.
Yeah, right.
You're picturing this massive muddy animal just standing there in the middle of a formal courtroom. But the wild thing is, that is a real scenario.
Wait, really?
Oh, absolutely. It's drawn from actual case law.
Yeah.
It details exactly how the machinery of public trust breaks down in the real world.
That is insane. Well, welcome to your custom-tailored deep dive. We are taking you on a journey into the architecture of accountability today.
It's going to be a fascinating one. It really is. Our foundational material today is this highly specific legal document. It's the Target 7 Syllabus in Criminal Law 2 for 2025-2026.
Authored by Lorenzo U. Padilla.
Yes, exactly.
Yeah.
And we're specifically examining Title 7 of the Revised Penal Code, which covers crimes committed by public officers. Now, I know what you're thinking.
You hear the phrase penal code syllabus and you just glaze over.
Right. You brace yourself for this incredibly dry, impenetrable wall of legal jargon.
Sure.
But the reality is completely the opposite.
Oh, totally. What Padilla has mapped out here, it's effectively a catalog of human temptation.
A catalog of temptation. I like that.
Because, the law can't just say, hey, don't be corrupt.
Right. That's way too broad.
Exactly. It has to anticipate and categorize and basically define every single way that greed, laziness, and arrogance actually manifest when you give people power over others.
And that is exactly our mission today. We're pulling out the most fascinating mechanisms from this document so you can understand how a society actually, mechanically, defines corruption.
Because if you really want to know how the guardrails of government work, you have to look at the exact points where the law expects the system to crash.
That's such a good way to put it. Okay, so to understand that, we first have to figure out who the law is actually aimed at.
Right. The target audience of the penal code?
Yeah, because when I say public officer, your mind probably jumps immediately to, like, a politician.
Sure. A senator,
a governor, maybe a police chief. People with heavy brass nameplates and elected terms.
Right. That's the natural assumption we all make. We equate the term with high-ranking visibility.
Exactly.
But Article 203 of the Revised Penal Code, which is what defines a public officer here, it operates on an entirely different philosophy.
How so?
Well, the syllabus points out that the defining characteristic isn't a title. It's the act of taking part in the performance of public functions in the government.
Okay.
Or performing public duties as an employee, an agent, or even a subordinate official.
There's actually a line in the text that completely shatters that traditional assumption. It just says, rank or class is immaterial.
Immaterial. That is the cornerstone of this entire legal framework.
Wow.
The Revised Penal Code basically views the machinery of government as this single contiguous entity.
Like one giant machine.
Exactly. And if you are operating even a tiny little gear in that machinery, the law places the exact same lens of accountability on you as it does on, say, the cabinet secretary running the whole department.
That is wild.
Yeah, the law cares intensely about the source of your authority, like whether you were elected or appointed by competent authority or directed by a provision of law. But it absolutely does not care how far down the organizational chart your name sits.
Okay, let's unpack this a bit, because the syllabus contrasts this with special laws, like Republic Act number 3019.
Right, the Anti-Graft and Corrupt Practices Act.
Yeah, or the Plunder Act.
Yeah.
Do those special laws define a public officer the same way?
Well, they cast an even wider institutional net, actually, but they approach it slightly differently.
Okay.
Those special laws explicitly expand the definition of the government to include government-owned or controlled corporations.
Oh, okay, so like state-run businesses.
Exactly, and their subsidiaries. But the Revised Penal Code, particularly Article 203, it remains laser-focused on the specific delegation of sovereign power.
So it's really about the nature of the duty itself.
Precisely. It's the action you're taking on behalf of the state.
And here is where the mechanics of that duty get really surprising. The syllabus explicitly states that someone who is hired as a laborer is not inherently a public officer.
Right.
So like if you're hired by the city to literally sweep the steps of City Hall, you don't hold the public trust in the same way a clerk or a mayor does.
Correct. Because the core function of a laborer is physical, right? It's not administrative or authoritative.
So they're generally outside the bounds of Title VII.
Generally, yes. However, the law contains this fascinating trapdoor.
Ooh, a trapdoor.
The temporary performance by a laborer of public functions completely alters their legal DNA. The exact moment they cross that line, they are completely transformed into a public officer.
Okay, the case law provided here is just wild. Take People versus Bolongo.
Oh, that's a perfect example.
We have this individual who was hired simply as a laborer, but for whatever reason, maybe the office was just really short-staffed that day, they were tasked with sorting and filing money orders.
Right, and think about the actual mechanism of a money order.
It's cash, essentially.
Exactly. It's a financial instrument. It's an asset moving through a state-controlled system. So it relies entirely on the integrity of the public servants handling it.
So the moment this laborer's hands touch those money orders, the moment they start organizing them,
They are no longer just a laborer.
the invisible weight of the Revised Penal Code just drops right onto them.
Exactly.
Or look at People versus Ireneo. You have someone designated as an emergency helper in the Bureau of Treasury, and suddenly they're deemed a public officer.
Right, because the Bureau of Treasury literally handles the state's wealth. If an emergency helper is suddenly given access to sensitive financial processes, or they're asked to perform a duty that safeguards those assets,
Even temporarily.
even temporarily, their temporary function totally overwrites their official job title.
That's amazing.
The law essentially refuses to allow a loophole, because otherwise, an agency could just hire someone under the title of helper to handle highly sensitive tasks.
And then they'd completely avoid the strict penalties of public accountability.
Exactly. It's brilliant.
So if I'm trying to picture how this works, imagine a typical high school, right?
Okay,
You have the principal, who clearly wields administrative authority.
sure.
And you have the night custodian, who doesn't. But let's say an emergency breaks out during the day. The principal grabs the custodian, hands them a set of master keys, and says, I need you to lock down the east wing, secure the students in the gym, and you have my full authority to control access to those doors.
Okay, high stakes.
Right. For that specific hour. If that custodian abuses that power, say they start extorting students for cash to let them out,
Which would be terrible.
awful. But legally, they aren't going to be judged as a custodian who misused a broom. They're going to be judged with the full weight of an administrator abusing state-granted authority.
Yep.
Because it's the action, not the badge on their shirt.
That analogy perfectly isolates the concept. Authority is totally fluid, and liability flows exactly where the authority goes.
Right.
The moment you are handed the lever of state power, no matter how briefly you hold it, you are held to the exact same standard as the person who normally pulls that lever.
It's just a brilliantly pragmatic way to design a law.
It really is.
But it also sets up a terrifying reality for anyone who holds permanent, high-level power. Because if the net is wide enough to catch an emergency helper, sorting mail,
The standard at the top is brutal.
exactly. The standards applied to the people at the very top of the legal food chain must be incredibly uncompromising.
Oh, they are.
We have to look at the people who literally decide the fate of others. How does the law handle judges who break the rules?
So this is where we shift our focus to malfeasance and misfeasance in office, specifically Articles 204 through 207.
Okay.
This whole section is essentially about the dereliction of the highest duty. And the syllabus focuses intensely on the crime of knowingly rendering an unjust judgment.
That's Article 204.
Right.
So for this to happen, let's break down the elements. The offender has to be a judge.
Yes.
They have to render a judgment in a case submitted to them. The judgment itself has to be unjust. And this seems to be the linchpin. They have to actually know it is unjust.
Right. That element of conscious knowledge, that is where the entire legal battle is fought.
Because how do you prove what's in someone's head?
Exactly. Petia's syllabus relies on cases like Santa Maria versus Ube to establish the baseline of what actually makes a judgment unjust.
What's the baseline?
It must be a decision that is manifestly contrary to law or entirely unsupported by the evidence, or both.
Okay.
And this is a massive busy, but the state cannot simply criminalize a judge just for being wrong.
Right, because the appellate courts exist for a reason. Judges are human beings. They're reading really complex precedents.
Exactly.
If every overturned decision resulted in a criminal charge, the justice system would freeze overnight. Nobody would ever want to be a judge.
Totally. The law meticulously carves out protection for honest errors.
Okay, right.
If a judge makes an error in good faith, or they misunderstand a statute, or they just evaluate the evidence poorly but honestly, there is absolutely no criminal liability under Article 204.
So being a bad judge isn't necessarily a criminal judge.
Right. You cannot base a charge of knowingly rendering an unjust judgment on a decision that's merely erroneous.
The state has to prove something darker.
They have to prove bad faith, ill motive, or improper consideration. And crucially, the unjust character of the judgment is never presumed just because a higher court overturned it.
It has to be proven as an independent fact.
Precisely.
Which brings us back to the Carabao.
Yes, the Carabao.
We mentioned U.S. versus Gacatan earlier. This is the ultimate example of improper consideration, right?
It is just a stark, undeniable breach of duty. You have a justice of the peace who completely disregarded the evidence in front of him.
He didn't just misinterpret a statute.
No, he abandoned the concept of evidence entirely. And he did it specifically because the winning party gave him a female Carabao.
Which, in an agrarian society, that is an incredibly valuable asset.
It's huge.
It's like a tractor, a source of income. It's a massive transfer of wealth. So when a judge trains the truth for a water buffalo, that is the conscious, malicious intent the law is hunting for.
Exactly. But what happens when that malicious intent cannot be definitively proven?
Because they don't always hand you a farm animal in public.
Right. The drafters of the Penal Code knew that proving a judge's internal state of mind, proving what they actually knew, is incredibly difficult.
Yeah.
So they created Article 205, judgment rendered through negligence.
Wait, so even without a Carabao, a judge can still be a criminal just for being negligent?
Yes. If the failure is spectacular enough, under Article 205, there might be absolutely no proof of conscious, deliberate intent to do an injustice. There's no bribe. There's no evidence of revenge.
Okay.
But the standard is that the judgment must be manifestly unjust.
The syllabus actually quotes an authority named Albert here. And the phrasing is just brutal.
Oh, I know the quote.
He says the decision must be so manifestly contrary to law that even a person with meager legal knowledge cannot doubt the injustice.
Ouch. Yeah, it cannot be a decision where two smart lawyers could have a reasonable debate about it.
Right.
It has to be a glaring, catastrophic failure of basic legal logic. And that failure must be driven by inexcusable negligence or total ignorance.
So it's one thing for a judge to, abuse their discretion without an ulterior motive.
Sure.
But it's entirely another for a judge to display a level of ignorance that proves they've just utterly abandoned the responsibilities of the bench.
Exactly. It's essentially the law saying, look, we can't definitively prove you are corrupt, but your decision is so bafflingly wrong that you are either corrupt or criminally incompetent.
And the accountability doesn't just wait for the final gavel strike either. Article 206 targets unjust interlocutory orders.
Right. Now, for those who might not know, an interlocutory order is a ruling made while the trial is still ongoing.
Like in the middle of it.
Yeah. It doesn't resolve the final merits of the case, but it handles procedural things, like granting bail or admitting a piece of evidence or issuing an injunction.
Which can be a big deal.
Massive. A judge can inflict massive damage on a litigant long before the final verdict is ever read.
True.
So if a judge knowingly issues a corrupt interlocutory order or does so through that same inexcusable negligence, they trigger criminal liability right then and there.
And what if the judge's weapon isn't a bad decision, but simply time itself?
Article 207.
Yeah, this covers malicious delay in the administration of justice. You have a judge, a pending proceeding, and a delay. But again, the syllabus really emphasizes the word malicious.
Because delay is, unfortunately, just a reality of the legal system.
Dockets are completely clogged.
Always. So a mere delay is just an administrative problem. But a malicious delay requires deliberate intent to actually inflict damage on the litigants.
So the judge has to be literally weaponizing the calendar.
Exactly. They are intentionally letting a case languish to financially ruin a party, or to force a settlement out of desperation, or to protect a political ally.
That is so insidious.
It really is.
And this intense focus on the internal intent, it applies to the other side of the courtroom as well. We have to look at the attorneys and the prosecutors.
Right.
Like Article 209 deals with the betrayal of trust by an attorney.
This article penetrates the absolute core of the attorney-client privilege.
Okay.
An attorney can face penalties for causing damage to a client through inexcusable negligence, sure. But the far more sensitive trigger here is the revelation of secrets.
Telling people what you told them in confidence.
Exactly. If an attorney reveals any of their client's secrets that they learned in a professional capacity, they commit a crime.
And the syllabus notes a really distinct mechanical difference here that I found interesting.
What's that?
If you're charging an attorney with inexcusable negligence, you actually have to prove that the negligence caused damage to the client.
Right. There has to be quantifiable harm.
But if you're charging them with revealing a secret, damage is not an essential element. The crime is literally just the act of opening your mouth.
Yep. Because the rationale there is systemic survival.
Systemic survival.
Think about it. The entire adversarial justice system relies on a client's absolute certainty that they can confess the darkest, most damaging truths to their lawyer.
Right, so the lawyer can actually build a proper defense.
Exactly. If attorneys are allowed to leak those secrets, even if the leak doesn't financially ruin the client, the trust in the entire system evaporates.
Citizens will just start lying to their own lawyers.
And then the courts will just be dealing with fictions. The system collapses.
That makes total sense.
Furthermore, Article 209 strictly penalizes an attorney who undertakes the defense of the opposing party in the same case without the consent of the first client. Yeah, you cannot leverage the intimate knowledge of one side to serve the other side later on.
Okay, I want to step in here and challenge how this applies to the prosecutor specifically. Because under Article 208, prosecution of offenses, negligence or tolerance.
Yes.
This article punishes a public officer who maliciously refrains from instituting prosecution against violators of the law.
Right.
So let's ground this in reality. Say my car gets stolen.
Okay.
I know exactly who did it. I have doorbell camera footage. I take the evidence to the prosecutor.
Excellent.
And the prosecutor just looks at it and says, yeah, I'm not filing charges. I'm dropping this. As a victim, I am going to feel like that is a profound injustice.
Naturally.
So where is the line between a prosecutor just doing their job and a prosecutor committing a crime under Article 208?
That is perhaps the most common friction point between everyday citizens and the justice system. And the syllabus addresses it by outlining the strict boundaries of prosecutorial discretion. Citing cases like Vida de Bagatua versus Revilla, the text clarifies that prosecuting officers are not under any absolute compulsion to file a case just because a complaint was made.
So they have the legal right to just say, no, we're not doing this.
Absolutely. If they are not convinced that the evidence is sufficient to secure a conviction in court, it is actually their duty not to clog the docket with a doomed case.
Oh, interesting.
Right. For a prosecutor to be criminally liable under Article 208, there must be a definitive dereliction of duty.
Meaning what exactly?
Meaning they must know a crime was committed, the evidence must be robust, and here's the key. They must act with malice and deliberate intent to favor the violator.
Malice is doing a lot of heavy lifting in this section.
It's the entirety of the crime. The syllabus emphasizes that malice requires more than just a voluntary act. It requires deliberate, evil intent.
Yep.
If a prosecutor genuinely evaluates the evidence and believes it's weak, even if literally every other lawyer in the city disagrees with them, that is an error of judgment. It's not a crime.
Okay.
But if they bury the case because the suspect is their cousin, or because the suspect slipped them an envelope of cash, that is malice.
And the syllabus notes a really specific procedural hurdle here, referencing U.S. versus Mendoza.
Yes.
It says you cannot convict an officer for malicious dereliction in failing to prosecute a crime unless the guilt of the original law violator is eventually proved.
Exactly, because logically you cannot be guilty of failing to prosecute a crime if it turns out the crime didn't actually happen.
Right, or couldn't be proven to have happened.
Exactly. The underlying offense must be a confirmed reality before the tolerance of it becomes a crime for the prosecutor.
That's fascinating. You know, we keep circling back to this idea of improper consideration.
The underlying transaction.
Yeah. A judge trading verdicts for livestock, a prosecutor burying a case for a friend. These acts of malfeasance rarely happen in a vacuum. They're usually fueled by a very specific transaction.
Money, favors, gifts.
Exactly. And that brings us to the centerpiece of Title VII. We need to dissect the actual mechanics of the exchange. We need to talk about bribery.
Bribery is the engine of systemic corruption.
The absolute engine.
And Lorenzo Padilla's syllabus breaks it down into this highly precise spectrum of offenses. It starts with Article 210, direct bribery.
I find the structure of Article 210 fascinating because it doesn't treat all bribes equally.
Not at all.
It organizes direct bribery into 3 distinct forms based on what the public officer is actually doing in exchange for the gift.
Let's look at the first form.
Yep.
In the first form, the public officer agrees to perform an act constituting a crime in connection with their official duties in consideration of an offer, promise, gift, or present.
So the act they're performing is independently illegal, regardless of the bribe.
Exactly.
Like, for example, a police officer taking cash to physically plant illegal drugs in someone's car. Planting evidence is a crime on its own.
Right. And the law reflects that dual severity. If the officer actually carries out the crime they agreed to commit, the penalty for the bribery is calculated in correspondence with the penalty for the underlying crime they committed.
Wow.
You are punished for the corruption and the subsequent felony.
Then we have the second form of direct bribery. This is when the officer accepts a gift in consideration of the execution of an act that does not constitute a crime, but is unjust and connected to their official duties.
This form is crucial because this covers the vast majority of bureaucratic corruption.
How so?
Because the act itself, the mechanical function, is totally legal. Issuing a permit is legal.
Right.
Granting a contract is legal. Handing down a verdict is legal.
Oh, this goes right back to our Carabeo judge.
Exactly.
Giving a verdict isn't a crime, but doing it without regard to the evidence, simply because someone gave you a water buffalo, makes the otherwise legal act profoundly unjust.
Precisely. And the law distinguishes the timeline here, too. The penalty differs depending on whether the corrupt official actually executed the unjust act or if they only made the agreement and accepted the bribe but hadn't yet followed through.
And then the third form of direct bribery covers the opposite of action.
Right, the omission.
It's when the public officer refrains or agrees to refrain from doing something which it is their official duty to do, entirely in consideration of a gift or promise.
The syllabus provides several really vivid examples of this. Take U.S. versus Navarro.
Okay.
You have a sanitary inspector. He discovers a building in a severely unsanitary condition.
Like a public health hazard.
Exactly. And it is his legal mandated duty to report this to his superiors so action can be taken to protect public health.
Sure.
But the tenant of the building approaches him, offers him a gift, and the inspector simply walks away and never files the report.
He literally gets paid to close his eyes.
Precisely. Or People versus Marco, where an individual refrained from reporting derogatory vital information about a suspect in a case because they were paid off.
The case of U.S. versus Aldahueza is perhaps the most glaring example of this third form, I think.
Oh, the prisoner transfer case.
Yes, you have a municipal officer who is holding a prisoner in custody. The provincial governor issues a direct, lawful order, transfer this prisoner to the provincial capital.
Simple enough.
The officer's official duty is to execute that transfer. Instead, the officer accepts 20 pesos from someone, unlocks the cell, and simply releases the prisoner.
For 20 pesos.
20 pesos. It seems like such a trivial amount to risk an entire career and your freedom over.
Well, we do have to remember the historical and economic context of older case law.
Yeah.
20 pesos represented significant purchasing power at the time.
Fair point.
But regardless of the era, the mechanism is exactly the same. The officer had a duty, a monetary consideration was introduced, the duty was abandoned. In all three of these forms of direct bribery, the defining element is the quid pro quo. The gift must be given specifically to corrupt the officer. It is the direct consideration for the act, the unjust act, or the omission.
Okay, let's explore a hypothetical boundary here because I think this is important for people to understand.
Sure, lay on me.
Let's say I am a corrupt public official A contractor comes to my office and says, I will give you 1,000,000 pesos right now if you award my company this bridge contract.
Okay.
I look at them, I smile, and I say, I accept your offer. Consider it done. We shake hands.
The deal is struck.
But before the contractor can actually transfer the money and before I can sign the contract, an undercover investigator kicks down the door.
Busted.
Right. But if I haven't received a single peso and I haven't awarded the contract yet, have I actually committed direct bribery?
This is a vital legal distinction, and the syllabus is absolutely unequivocal on this point.
Right.
The gift or present does not need to be physically received. The crime of bribery is consummated the exact moment you accept the offer or promise.
Wait, so the agreement itself is the radioactive element?
Yes. The law penalizes the corruption of the mind, the willingness to betray the public trust. By saying, I accept your offer, you have already traded away your impartiality.
Wow.
The transaction of the money is just logistics at that point. The crime is complete.
But what if I am a fundamentally honest official? The contractor offers me 1,000,000 pesos and I immediately say, no, get out of my office, I'm calling the police.
In that scenario, you have committed no crime whatsoever. The offer was rejected.
Okay, good to know.
However, the contractor, the private citizen who attempted to initiate the corruption, is now liable for attempted corruption of a public officer under Article 212.
Ah, okay. So direct bribery is a very clear transaction. A specific favor is bought and paid for.
Exactly.
But the syllabus also spends significant time on Article 211, indirect bribery. How does the mechanism change here?
So indirect bribery removes the immediate, explicit quid pro quo from the equation entirely. The elements are simple. The offender is a public officer, they accept gifts, and those gifts are offered to them by reason of their office.
By reason of their office. So the person giving the gift isn't asking for anything right then and there.
No.
They aren't saying, here is a Rolex, approve my permit.
Exactly. The syllabus points out that these gifts are usually given in anticipation of a future favor.
It's playing the long game.
It is about cultivating a fertile ground of undue influence. The giver is buying goodwill. They know that down the line, when they need a regulatory favor or a contract, the public officer will remember who bought them dinner or sent them expensive wine.
The text highlights U.S. versus Richards for this.
Oh, the mules?
Yeah. It involves a veterinarian working for the Board of Health. His specific job was to examine mules that were being sold to the government.
Right.
After the vendor successfully sold the mules and received full payment from the government, the vendor went back and gave money to the veterinarian.
Which looks suspicious.
Right, but there was no evidence of a prior agreement. The mules had already passed inspection. The money was paid. Why is that still a crime?
Because the money was given entirely due to the position the veterinarian held and the influence he had just wielded. Even if the vendor wasn't buying a specific future favor right then, they were rewarding a public officer for doing their job, which completely compromises the officer's future impartiality with that vendor or any other vendor.
That makes a lot of sense.
And crucially, unlike direct bribery, where an accepted promise is enough to be guilty, Reyes notes in the syllabus that for indirect bribery, there is no frustrated or attempted stage.
Meaning?
The crime only exists if the gift is actually accepted.
Okay. Now, this concept of indirect influence leads to a massive cultural friction point, which the syllabus addresses by citing Presidential Decree number 46.
Yes.
This decree specifically criminalizes receiving and giving gifts on any occasion, explicitly including Christmas.
It does.
It even prohibits throwing parties or entertainments in honor of an official if it's done because of their position.
It is a deliberate, forceful attempt to sever deeply ingrained cultural practices of gift-giving from the administration of state power.
Because in many cultures, giving gifts to people of authority during holidays is just seen as a sign of respect.
Exactly. It's totally normal socially. But the law has to step in and aggressively categorize that as a vector for corruption.
And the Anti-Graft and Corrupt Practices Act, RA 3019, also addresses this. It acknowledges that gifts happen during family celebrations or national festivities, but it makes it a crime if the value of the gift is manifestly excessive under the circumstances.
Right.
So the law is trying to draw a line between genuine human connection and disguised bribery.
Exactly. The law knows the difference between a citizen dropping off a box of pastries at the local firehouse just to say thank you.
Right, totally innocent.
And a government defense contractor dropping off the keys to a luxury SUV to a procurement general and calling it a Christmas present.
Yeah, big difference.
Yeah.
But practically speaking, how does the state ever actually prosecute this?
It's incredibly hard.
Bribery is a crime that happens in the shadows. Both the official taking the bribe and the citizen paying it are guilty. If they both go to jail for talking, neither of them will ever talk. They are locked in a mutual pact of silence.
That is the ultimate investigative paradox of corruption.
So how do you break it?
To solve it, the legal system had to design a very specific tool to break the stalemate. The syllabus introduces Presidential Decree number 749, which grants immunity from prosecution to the givers of bribes.
Immunity. So the law actually says to the person who funded the corruption, you get to walk away.
Under incredibly strict, mathematically precise conditions, it is a calculated compromise by the state.
Tell me more.
The state basically decides that surgically removing a corrupt public official from the machinery of government is vastly more important to the health of the republic than punishing the private citizen who handed over the envelope.
It's the prisoner's dilemma codified into a presidential decree.
Exactly what it is. But to claim this immunity, the bribe giver has to clear several major hurdles. They must voluntarily come forward and give the information. The information must relate to specific violations like the Anti-Graft law or bribery statutes.
Okay.
They must be completely willing to testify against the public official in court.
They have to take the stand.
Yep. The information they provide must be absolutely necessary for a conviction, meaning the state didn't already have enough evidence to win without them.
So they can't just jump on a sinking ship to save themselves.
Right. The testimony must be corroborated by other evidence. And, crucially, the informant must not have been previously convicted of a crime involving moral turpitude.
So you cannot be a career scam artist or an extortionist and use this law as a shield to wipe away your crimes.
Definitely not.
You have to be somewhat clean in the eyes of the law, and you have to deliver the corrupt official with absolutely airtight testimony.
And the syllabus includes a severe warning clause about this.
What's the warning?
If you come forward, claim immunity. And it turns out the information you provided was false and malicious-like. If you were just trying to frame or harass a public officer, the immunity vaporizes.
Oh.
You will immediately face criminal and civil liability for perjury and whatever damages you caused.
Okay, so far, our exploration of corruption has focused entirely on external influence.
Right, people outside the government trying to influence the inside.
Bribery is about illegal assets, gifts, cash, livestock flowing into a public official's hands from the outside, corrupting their decision-making process.
Yes.
But what happens when the money is already inside the building? What happens when a public officer is sitting on a mountain of state assets and those assets start illegally flowing out?
That introduces an entirely different mechanism of failure.
Let's follow the money into the realm of frauds, exactions, and malversation.
Yes, we are shifting from the corruption of outside influence to the profound betrayal of internal custody. Chapter 3 begins with Article 213, which handles frauds against the public treasury and illegal exactions.
Frauds against the public treasury targets a very specific scenario. The elements require a public officer who takes advantage of their office to intervene in a transaction.
Right, like purchasing supplies for the state or finalizing a massive construction contract.
And then they enter into an agreement with an interested party to defraud the government. What stands out to me here is the timing of the crime.
Yes, the timing is everything. The crime is consummated the very moment the officer enters into the agreement to defraud.
The actual outcome doesn't matter.
Not at all. If an official schemes with a concrete supplier to inflate the cost of a highway project by 30%, the crime is complete the absolute second they shake hands on the rig deal.
Wow.
Even if the project gets canceled the very next day. Or an auditor catches the inflated numbers before a single peso is paid out, the official is still guilty.
Because the betrayal happened at the handshake.
Exactly. The law is punishing the fundamental betrayal of the fiduciary duty at its inception.
The second half of Article 213 deals with illegal exactions. Now, this feels like a much more intimate, face-to-face abuse of power.
It is.
It occurs when a public officer who is legally entrusted with collecting taxes, licenses, or fees uses that power to extract more than what is authorized.
It is the raw abuse of the collection mechanism. Imagine an everyday citizen going to a local office to pay a standard licensing fee.
Right.
The law dictates the fee is 500 pesos. The officer looks at the citizen, demands 1,000 pesos, and just pockets the difference.
Simple theft by authority.
Or They collect the correct 500 pesos, but they voluntarily fail to issue a receipt.
Because without a receipt, there is literally no paper trail.
Exactly.
The money essentially doesn't exist in the state's eyes,
Yeah.
and the officer can quietly slide it into their own drawer.
But the syllabus draws a fascinating and highly technical distinction here regarding the method of the exaction.
What's the distinction?
If an officer demands a larger fee, but they do it by actively deceiving the citizen.
How would they do that?
For example, if they create fake documents or lie about a brand new tax law to trick the citizen into handing over more money, the crime actually morphs.
Like the case of U.S. versus Lopez.
Yes, exactly. A municipal treasurer was registering and branding cattle. He actively lied to the residents, telling them the legal fee had increased, tricking them into overpaying.
Wow.
The court ruled that because he used deceit to obtain the money, the crime was actually estafa, which is swindling, rather than a simple illegal exaction.
Because illegal exaction relies on the sheer weight of authority to force the overpayment, while estafa relies on fraud.
Precisely. It's a subtle but massive legal difference.
Okay, we are now arriving at the apex predator of financial crimes in the public sector.
Here we go.
Article 217, malversation of public funds or property. Whenever a massive political scandal hits the news, malversation is the word blinking in neon lights. Let's break down the mechanics of this.
Malversation is, at its core, the embezzlement of public assets by the exact person legally sworn to guard them. The elements define a very specific relationship. The offender must be a public officer. They must have custody or control of funds or property explicitly by reason of their office.
Right.
Those funds must be public funds for which they are personally accountable. And finally, they either appropriate the funds, take them, misappropriate them, or consent to another person taking them.
I really want to dissect the concept of public funds because the syllabus threw a massive curveball at me here.
Oh, I know what you're going to say.
When I think of public funds, I think of tax revenue, right?
Yeah.
Money collected by the government for the government.
Sure.
But the text cites cases like People versus Velasquez and People versus De La Serna, and lists things like Red Cross funds, Anti-Tuberculosis Society funds, and Boy Scout funds.
Yeah. Right.
How on earth do private donations to the Boy Scouts become public funds?
This reveals a profound legal philosophy regarding custody. The nature of the funds can actually be transformed by the hands that hold them.
Transform.
It isn't just about the origin of the money. It is about the nature of the accountability. If a public officer operating in their official capacity receives funds that they are legally obligated to account for.
Even if those funds originated from private donations or charitable organizations.
Yes. Those funds become impressed with a public character.
So if a municipal treasurer is tasked by a local ordinance to temporarily hold the charity drive money, it effectively becomes state money for the purpose of criminal liability.
Yes. The same logic applies to private property seized by the police or a sheriff.
Oh, interesting.
If a police officer seizes a civilian's private car as evidence in a crime, and then the officer decides to strip the engine and sell the parts, they can be charged with malversation.
Because even though the car isn't owned by the government.
The government's custody of it is absolute, and violating that custody is malversation.
Now, here is the mechanism that should terrify any public accountant listening. The presumption of malversation.
Oh, it's brutal.
It completely flips the standard rules of criminal justice.
It is a devastating legal tool. In a standard criminal trial, the burden of proof rests entirely on the state.
Right. Innocent until proven guilty.
The state must prove, beyond a reasonable doubt, that you committed the act. But under Article 217, the law alters reality.
How so?
It states that the failure of a public officer to have duly forthcoming any public funds or property upon demand by any duly authorized officer shall be prima facie evidence that they have put such missing funds to personal use.
Let me make sure I'm understanding the gravity of this.
Go ahead.
If an auditor from the Commission on Audit walks into a provincial treasurer's office, asks to see the vault, and the vault is short by 1 million pesos, the auditor doesn't need to find a paper trail.
Nope.
They don't need to find a secret bank account in the Cayman Islands or catch the treasurer buying a sports car.
Absolutely not.
The mere fact that the safe is empty is enough for the law to legally presume the treasurer stole it.
Exactly.
The burden of defense instantly drops onto the accused to prove they didn't.
That is exactly how it works. It forces absolute, uncompromising meticulousness. If you cannot explain the shortage satisfactorily, the presumption becomes a conviction.
That is heavy.
And this leads to perhaps the most fascinating anomaly in the entire penal code, which the syllabus explicitly highlights as an exception to the general rules of criminal law.
What's that?
The penalty for negligence.
Right. Normally, if I do something terrible on purpose like deliberate murder, the penalty is massive.
Sure.
If I cause a death through a tragic accident or criminal negligence manslaughter, the penalty is significantly lower. The law recognizes that malice is worse than stupidity.
Exactly. Intent usually scales the punishment. But in malversation, the penalty is identical. Whether you deliberately engineered a complex scheme to pocket 1 million pesos, or you just negligently left the vault door wide open and went home, allowing a stranger to walk in and steal it, you face the exact same penalty.
Why? Why would the law punish a fool the exact same as a thief?
Because from the perspective of the state's survival, the damage is identical. The public trust is broken, and the resources required to run the government are gone. You were assigned one specific duty: be the absolute guardian of this asset.
And you failed.
Whether you actively betrayed that duty or passively abandoned it through inexcusable negligence, you have failed the state to the exact same degree.
Okay, let's explore the boundaries of that negligence.
Yeah.
Let's say I am that treasurer. I lock the money in a heavy steel safe. I lock the office door.
Do your job.
In the middle of the night, a professional crew of bank robbers blows the wall open with dynamite, torches the safe, and steals the money. Am I guilty of malversation through negligence? Do I go to prison for 20 years because the money is gone?
No, and the syllabus relies on jurisprudence to define what actually constitutes criminal negligence in these cases.
Okay, good. So what's the standard?
The negligence must be positively and clearly shown to be inexcusable, approximating malice or fraud. If you took reasonable standard precautions and were overpowered by superior force or an unforeseeable event, you are not criminally liable.
So if the robbers blow the vault, I am a victim. But what does negligence approximating malice look like in reality?
The text gives us People versus Lintao. A public officer was caught cashing private checks with public funds, directly violating standing government regulations.
Well.
That isn't just a simple mistake. That is an active, reckless disregard for the rules that directly endangers the funds.
Right.
Or People versus Torres, where an accountable officer entrusted a massive sum of public money to a mere driver to deliver without any security or supervision.
So, to build on my analogy, if the dynamite crew hits the safe, I'm clear.
You're clear.
But if I decide to prop the vault door open with a chair so the room gets a nice cross breeze,
Oh, no.
and then I go out for a 3-hour lunch and someone wanders in and takes the cash, that is inexcusable negligence approximating malice.
Precisely. The legal standard of care must be commensurate with the occasion. If you are guarding a box of utensils, the standard of care is low. If you are guarding 100 million pesos, your standard of care must be exceptionally, flawlessly high.
Now, what happens if an officer gets audited? The auditor says, you are short 50,000 pesos, and the officer panics. They say, wait, and they immediately pull 50,000 out of their own personal bank account and put it on the table. Does returning the money erase the crime?
The law is ruthless here. The return of funds malversed is considered only a mitigating circumstance.
Not an exempting one.
It is not exempting. Restitution does not undo the fact that you violated the public trust. It merely shows remorse, which might slightly lower the duration of your sentence. You are still a convicted criminal.
But the syllabus notes one incredibly narrow, almost microscopic loophole here, citing the Feliciano case.
Ah, yes, the split-second exception.
The split-second exception.
In very rare instances, courts have held that if an officer pays the shortage from their own pocket the very moment the shortage is discovered during an examination, no prima facie evidence of malversation was fully established.
But it has to be their own money, immediately available.
Yes.
The syllabus brings up the tragicomic case of People versus Divino to show how incredibly strict this is.
Oh, that case is tough to read.
An officer was being audited. The auditor found a shortage. The officer panicked, ran out of the room, found his own subordinate clerk, begged to borrow the money, ran back in, and tried to hand it to the auditor to cover the gap.
And the court rejected it entirely.
Completely.
Borrowing money from your own staff after the shortage is declared does not invoke the Feliciano exception. It simply proves you didn't have the money you were supposed to have.
You can't just treat the public treasury as a personal revolving credit line.
Exactly. Pulling money out and hoping to put it back before the music stops is a crime.
And the state is so paranoid about this that they criminalize the mere delay of paperwork. Article 218 covers the failure of an accountable officer to render accounts.
This is wild.
You don't even have to be missing a single centavo. If the Commission on Audit requires your ledger by the 1st of the month, and you just fail to submit it for 2 months, you have committed a crime. Why?
Well, as the Saborn case points out, the government relies entirely on the continuous flow of accounting data to ensure the Treasury is secure.
Right.
If an officer goes dark and stops reporting, the state has to assume the worst.
The overarching lesson of this entire segment is that holding public property is an immense, unforgiving burden. You are not an owner. You are a guardian. And the mechanisms designed to punish a failure of that guardianship are draconian by necessity.
Which provides the perfect conceptual pivot for us.
Yes. We've spent a long time looking at the custody of inanimate objects. Money, checks, physical assets. But what happens when the asset you are legally bound to guard is a human being?
The standard of negligence and the whole philosophy of custody change completely.
We are moving into Chapter 5 of the syllabus, Infidelity of Public Officers, specifically looking at prisoners, papers, and secrets.
When a public officer is handed custody of a prisoner, they are being handed the ultimate coercive power of the state.
The deprivation of a citizen's liberty.
Exactly. Articles 223 through 225 cover what happens when that specific custody is betrayed.
Let's start with Article 223. Conniving with or consenting to evasion. A prisoner escapes, and the guard was in on it.
Connivance is the key word there. It implies shared knowledge, an active agreement.
Like the guard unlocks the back gate, checks their watch, and turns around so the prisoner can run.
Right. But the syllabus points out that mere leniency or laxity on the part of a guard does not automatically equal connivance. However, there is a concept within this article called relaxation of imprisonment that is absolutely fascinating.
What does that actually mean in practice? Because it doesn't sound like a full escape.
It isn't a full escape in the sense of, running away into the mountains. Relaxation of imprisonment occurs when the guard fundamentally alters the physical and psychological reality of the sentence to the point that it constitutes a real evasion of the law's intent.
Give me an example. The syllabus has some incredible narrative examples of this.
Look at People versus Revilla.
Right.
A prisoner was serving a very short 6-day sentence. The guard, rather than keeping the prisoner in the cell, allowed the prisoner to sleep and eat in the guard's own personal house.
And the excuse given in the case was that there was a lack of budget for prisoner food.
Right.
Yes.
The guard probably thought they were being pragmatic, or maybe even kind. They were solving a logistical problem.
But the court looked at that and said, absolutely not. That is a relaxation of imprisonment.
Because it doesn't feel like prison anymore.
The law demands that a penalty must be felt as a penalty. If a prisoner is lounging in a guard's living room eating home-cooked meals, the deprivation of liberty is rendered entirely ineffectual. It becomes a vacation, not a sentence.
Or look at People versus Evangelista. This one shows a much darker dynamic. A mayor took a prisoner out of custody and utilized their services for domestic chores in the mayor's own house.
That is a perversion of the justice system into feudal labor.
It's disgusting.
The state sanctions imprisonment to punish a crime against society, not to provide free household staff for local politicians. By turning the prisoner into a domestic servant, the mayor was guilty of conniving in the evasion of the true sentence.
Okay, so that covers intentional connivance and relaxation. What about Article 224, evasion through negligence? This is the guard who simply screws up.
The penalty for the guard is the same, whether the escapee is a detention prisoner just waiting for trial or a convicted murderer serving a final sentence.
Wow.
The breach of the officer's duty is identical. But again, the law has to distinguish between a momentary human distraction and criminal negligence. What is punished is a definite laxity that amounts to a deliberate non-performance of duty.
The case law here plays out almost like scenes from a movie. In People versus Gayab, the guard simply fell asleep on duty and the prisoner walked out.
Classic negligence.
In Remoco versus People, the escape occurred because the guard was completely absorbed in answering a telephone call.
Distraction.
But the most illustrative case, the one that paints the clearest picture of what deliberate non-performance looks like, is People versus Legata.
Oh, the Legata case. It perfectly isolates the concept of foreseeable risk.
Walk me through it.
A guard permitted a prisoner to leave the secure area and go gather gabi, which is a type of root vegetable in the nearby nursery.
And the court specifically noted the geography of this nursery.
Oh, heavily.
It was grassy, overgrown, visually obscured. The court described it as a choice place for a prisoner who may want to escape.
Exactly. The guards' negligence wasn't just that they looked away for a second. The negligence was the active decision to place the prisoner in an environment that inherently defeated the purpose of custody.
Right.
If you put a prisoner in a grassy field with zero structural containment just to grab some vegetables, you have completely abandoned the standard of care required of a state custodian. You facilitated the escape through sheer recklessness.
Now, what if the guard realizes their mistake immediately?
Like they see them running.
Yeah. The prisoner bolts into the grassy field, the guard drops their radio, sprints after them, tracks them through the brush, and an hour later drags them back to the cell by the collar. Is the guard off the hook because they successfully fixed the problem?
According to the syllabus, citing the ruling in People versus Queasel, no.
No.
Recapture by the offender does not afford complete exculpation.
That is incredibly strict.
It has to be. The crime of evasion through negligence was consummated the exact moment the prisoner successfully broke from the guard's control due to that negligence.
Putting them back doesn't undo the break.
Putting the prisoner back in the cell mitigates the damage to society, sure, but it does not erase the fact that the absolute duty of custody was breached.
Okay, so that is the custody of human beings.
Mm-hmm.
But the state also runs on information.
Yes, the paper trail.
Article 226 tackles infidelity in the custody of documents. It penalizes a public officer who abstracts, destroys, or conceals documents or papers entrusted to them.
The core philosophy here is the protection of the public record.
Right.
The administrative state relies entirely on citizens trusting that when they hand over a document, a deed, a tax return, a piece of evidence, it is safe from tampering. If that trust collapses, the entire bureaucracy paralyzes.
But the syllabus makes a really interesting distinction about what the law actually considers a document or paper. It notes that books, pamphlets, and periodicals don't count.
Right. A clerk isn't committing a felony if they throw away a 3-year-old magazine from the waiting room.
But the definition of papers includes things you might not immediately classify as documents: checks, promissory notes, and paper money.
The inclusion of paper money is vital, and it hinges on the Grospic case.
U.S. versus Grospic.
Yes. It involved a postmaster who intercepted a registered letter, opened it, found paper money inside, and took it. Now, you might think that's just simple theft.
Yeah, that sounds like theft.
But the court ruled it was infidelity in the custody of documents. While the paper money was inside the sealed envelope moving through the mail stream, it was treated as a paper entrusted to his official custody as a postmaster.
And the disruption of that mail stream doesn't even require theft to be a crime. Look at U.S. versus Marino.
Oh, the hoarding case.
Exactly. The individual simply retained mail. They hoarded letters in a drawer without forwarding them to their destinations. They didn't steal the contents, they just stopped the flow. Why is that considered a severe crime?
Because the court stated it causes a real and positive injury to the public service and, hence, to public interest.
How so?
Imagine the cascading damage of hoarded mail. A citizen misses a court summons and a warrant is issued for their arrest. A business doesn't receive a critical payment and goes bankrupt. A family misses a letter from a dying relative.
Wow.
The injury to the public interest is inherent in the disruption of the service itself.
The law is so uncompromising here that the act of removal of a document is deemed consummated the exact moment it is secreted away from its usual proper place.
Immediately.
It absolutely does not matter if the officer intended to put it back later. If you take a deed out of the vault to temporarily leverage it, the crime is done.
And this section logically flows right into Articles 229 and 230, revelation of secrets.
Okay.
This applies when a public officer knows a secret by reason of their official capacity, whether it's a state secret that affects public interest or the private secrets of an individual citizen, and reveals it without authority.
Which is the bedrock of modern government operation. If you are a health inspector, a tax auditor, or a social worker, the state forces citizens to open the most private, vulnerable details of their lives to you.
You have no choice.
If a tax auditor goes to a dinner party and starts casually gossiping about the financial ruin of the local bakery, they are just being rude. They are actively destroying the faith that allows the government to function.
The syllabus states the explicit purpose of this law is to uphold faith and trust in public service.
Because without that faith, citizens will systematically hide information. Businesses will dodge audits, and the government will be operating in the dark.
It is all about maintaining the structural integrity of the system.
But as we look back over what we've discussed so far, the guard falling asleep, the clerk hoarding mail, the judge taking a bribe.
Yeah.
Many of these crimes stem from passive failures, quiet greed, or taking unseen advantage of a situation.
True.
But Lorenzo Padilla's syllabus doesn't stop there. It moves into the loud crimes, the aggressive, intentional, arrogant abuses of state authority.
We enter Chapter 6 of the syllabus. Other offenses or irregularities by public officers.
This is where things get really intense.
This section deals directly with the structural hierarchy of government and the chaos that erupts when officers actively weaponize their power or refuse to acknowledge their limits.
Let's start with the concept of open disobedience, governed by Articles 231 and 232. This occurs when a judicial or executive officer openly refuses to execute a judgment, decision, or order of a superior authority without any legal justification.
The syllabus outlines a very specific escalating dynamic to illustrate this. Imagine a superior officer issues a lawful order.
Okay.
The subordinate officer looks at it and decides to suspend the execution of that order for some reason. The superior reviews the situation and says, "No, I disapprove of your suspension. You must execute the order immediately."
And then?
If the subordinate officer still openly disobeys, despite that direct disapproval, they violate Article 232.
Why is this carved out as a specific severe crime? I mean, why not just fire them for insubordination?
Because, as the syllabus explains, by their persistent resistance and refusal to obey, the inferior officer effectively undertakes to dictate to their superior.
Ah, so it flips the hierarchy.
It is a fundamental subversion of the chain of command. The state cannot function if every subordinate employee decides their personal judgment supersedes the lawful constitutional orders of the command structure. It creates bureaucratic anarchy.
Right.
Now, obviously, if the superior's order is blatantly illegal, like ordering a subordinate to commit murder, that is a different scenario. But for lawful administrative orders, open disobedience is treated as a structural threat to the state.
And the sheer arrogance involved in some of these cases can be staggering. The text cites People versus Castro.
Oh, the police chief.
Yes, you have a chief of police who is formally requested to serve a summons by a provincial fiscal, essentially a prosecutor. The police chief flatly and insolently refuses to do it, just looks at the prosecutor and says no.
Which triggers Article 233, refusal of assistance.
Exactly. When a competent authority demands your cooperation for the administration of justice, and you maliciously fail to cooperate, causing damage to the public interest, you are criminalizing your own stubbornness.
That structural threat continues with the concept of usurpation of powers, spanning Articles 239 through 241.
This forces us to revisit the absolute basics of civics, the separation of powers, legislative, executive, judicial.
Right. Article 239 penalizes an executive or judicial officer who usurps legislative powers, like a mayor trying to unilaterally make general rules that require a city council vote or trying to repeal a law.
Okay.
Article 240 targets a judge assuming power that belongs to executive authorities. And Article 241 is an executive officer, like a police chief or a governor, assuming judicial powers.
It is the penal code explicitly saying, stay in your lane.
The balance of power in a democracy is incredibly fragile. If a mayor starts acting like a judge, issuing verdicts, declaring guilt, and ordering punishments, or if a judge starts acting like an executive commanding police forces to execute raids based on personal whim, the entire constitutional framework fractures.
Yeah, that's dangerous.
The law heavily penalizes this boundary crossing to protect the system from collapsing into authoritarianism at the local level.
Now, we need to confront Article 235, maltreatment of prisoners. We discussed guards letting prisoners escape through negligence, but this is the darker, intentional side of custody.
This is a tough one.
This is about the physical and psychological abuse of the utterly helpless.
The required elements are that a public officer has charge of a prisoner or detention prisoner, and they maltreat them. The syllabus is highly specific about how this maltreatment manifests.
What does it include?
It includes overdoing themselves in the correction or handling of the prisoner, imposing punishment that is not authorized by regulations, inflicting an authorized punishment, but doing so in a cruel and humiliating manner. Or, and this is heavily scrutinized by the courts maltreating prisoners, to extort a confession or obtain information.
The text mentions People versus Javier. In this case, a jailer inflicted injuries on a prisoner, specifically due to a personal grudge.
A personal vendetta.
It is the ultimate sickening abuse of the power dynamic. You have a human being locked in a cage, entirely dependent on you for their basic survival, and you use your state-granted authority to carry out a personal vendetta.
Or worse, to literally beat a confession out of them to close a case. And the syllabus makes a vital legal distinction here regarding the charges.
What's that?
The liability for the physical injuries caused is separate from the liability under Article 235.
So they get hit twice.
Exactly. If a jailer breaks a prisoner's arm, they get charged with the crime of physical injuries, and they also get charged with maltreatment of a prisoner.
Wow.
The law recognizes that violence committed under the color of state authority is inherently more dangerous, more corrosive to society than a standard bar fight between two civilians. It degrades the moral authority of the state itself.
And speaking of degrading the state and exploiting a vulnerability, we must examine Section 4, Abuses Against Chastity, Article 245.
This is a profoundly disturbing but absolutely necessary inclusion in the Penal Code. It penalizes a public officer who solicits or makes immoral or indecent advances to a woman.
But the law is not acting as a general morality police here, right?
No, not at all. It specifically protects women who are uniquely structurally vulnerable to the officer's specific power.
Right. The syllabus lists 3 specific classes of victims. 1, a woman interested in matters pending before the officer for a decision. 2, a woman under the custody of the offender, like a female prisoner with a warden. 3, the wife, daughter, sister, or relative of a person who is in the custody of the offender.
It is the absolute weaponization of bureaucracy and the justice system for sexual exploitation.
Horrific.
The officer is leveraging the crushing weight of the state. They are using a pending business permit or the threat of a harsher prison environment for a husband to extort sexual favors from desperate people.
And the most crucial, defining detail the syllabus provides about this crime is when it is actually completed.
The timing is key.
The crime of abuses against chastity is consummated by mere proposal.
Yes. The prosecution does not have to prove that physical contact ever occurred.
That's significant.
The moment the warden looks at the prisoner's wife and says, "I can make things much easier for your husband in here if you do this for me," the crime is absolutely complete.
The proposal itself is the crime.
The solicitation itself, the act of holding state power over someone's head while persistently propositioning them, is the profound injury the law is punishing.
It is horrifying to think about, but it demonstrates the law's attempt to draw an impenetrable, electrified fence around the most vulnerable points of interaction between private citizens and the power of the state.
It's trying to protect the powerless.
Now, before we wrap up this deep dive, I want to explore one more subtle, almost invisible abuse of power. Article 244, unlawful appointments. Let's ground this in a real-world hypothetical.
Okay, let's hear it.
Let's say I get elected mayor of a town. I have a buddy who helped me run my campaign. He is completely objectively unqualified for public office. He doesn't have the required civil service eligibility. Maybe he lacks the educational requirements, but I want to reward him for his loyalty.
Classic nepotism setup.
So I write a glowing letter recommending him for the position of municipal engineer. If I recommend my wildly unqualified buddy, am I a criminal under Article 244?
No, not merely for the act of recommending him.
Oh, really?
The syllabus specifically clarifies the text of the law. Making a recommendation for an unqualified person isn't the crime. The crime is committed specifically by the public officer who actually nominates or appoints them to the public office.
Okay, so if the human resources director or the appointing council takes my terrible recommendation and actually gives them the job, they are the ones committing the crime.
But there is another critical required element regarding their knowledge. The person nominated must lack the legal qualification for the office, yes, but the offender making the appointment must know that the nominee lacks those qualifications at the exact time they make the appointment.
So if my buddy forged his engineering degree and the appointing authority honestly believes the forged documents and hires him, the appointing authority isn't committing unlawful appointment.
Exactly. They were deceived, not malicious. To violate Article 244, the appointing officer must consciously, knowingly bypass the legal requirements to install an unqualified person into a position of power.
It's a direct, codified strike against nepotism, cronyism, and the patronage system.
It demands that the machinery of government be operated by people legally fit to run it, not just whoever happens to be closest to the seat of power.
It all constantly circles back to the integrity of the system.
Always.
Wow. We have covered an immense, complex landscape today. We have essentially mapped out the entire dark side of the bureaucratic moon.
It really is the dark side.
Let me try to synthesize this vast journey for you. We started this deep dive looking at Lorenzo Padilla's syllabus, not as a dry list of rules, but as a schematic for the architecture of accountability.
Right.
We have seen every conceivable way that human frailty violently intersects with public power. We examined how the law casts a net so wide it catches a laborer sorting mail, proving that the public trust is anchored to the function you perform, not the title on your door.
Function over title.
We unpacked the absurdity and the dark reality of a judge abandoning evidence for a water buffalo. We explored the nuanced spectrum of bribery, moving from explicit criminal transactions to the insidious, long-term influence of a Christmas gift.
Which is such a hard line to draw.
We followed the money, learning how an empty safe triggers the terrifying presumption of malversation, shifting the entire burden of proof onto the guardian. We realized that falling asleep on guard duty or hoarding letters in a desk drawer are not just mistakes, but profound betrayals of the state.
Betrayals of custody.
And finally, we confronted the sheer, aggressive arrogance of power, from a police chief insolently ignoring a prosecutor's order to the horrifying extortion of the vulnerable. These statutes, these articles from the Revised Penal Code, they are the invisible guardrails of a functioning society. They are the load-bearing walls that keep the entire blueprint of government from collapsing.
They are indeed the load-bearing walls. And as we conclude our analysis of this syllabus, I want to leave you with a final thought to mull over, one that stretches beyond the text itself.
Okay, let's hear it.
We have spent this entire deep dive looking intently at the mechanics of the law, at how the penal code so brilliantly codifies, categorizes, and punishes the failures of public officers. We have marveled at the design of the machinery of accountability.
It is brilliant design.
But consider this reality. Machinery does not run on its own. These laws, as perfectly written, as nuanced, and as strict as they might be, remain completely dormant ink on paper unless there are people brave enough to trigger them.
Wow.
The architecture of accountability relies entirely on the citizen who looks an official in the eye and refuses to pay the illegal exaction. It relies on the clerk who audits the vault, sees the missing funds, and reports it instead of lending their boss the money to cover it up.
Right.
It relies on the individual who utilizes PD 749 to step forward out of the shadows, claim immunity, and admit they paid a bribe so that a deeply entrenched, corrupt official can finally be removed.
That takes guts.
The syllabus outlines the crimes in exhaustive, brilliant detail, but it is the vigilance of the everyday citizen, the people living their lives entirely outside the syllabus, that actually breathes life into these laws. Without a whistleblower, without a complainant, a corrupt judge's carabao is just a pet.
Right.
An illegal exaction is just an annoying tax. A hoarded letter is just lost mail. So the question that lingers after reading all these rules is this. How much of our public accountability truly relies on the perfection of the legal blueprint, and how much of it relies entirely on the courage of the governed?
That is a profoundly powerful question. The law provides the blueprint, but courage is the foundation it has to be built on. Thank you for joining us on this incredibly detailed, custom-tailored journey into the architecture of accountability. Keep questioning the structures of power around you, keep looking for where the trust is held, and keep demanding that the machinery works the way it was designed to.
Welcome to the debate. So think about how a massive corporate computer network handles security, right?
Okay, yeah. Like with permissions and firewalls?
Exactly. If you're just a standard guest user, you can hardly open a file without triggering a warning. But if the system administrator grants you admin rights, even just temporarily, maybe so you can fix a single local printer, you suddenly have the power to alter the entire database.
Right. And with that immense power comes, an equally immense firewall of tracking and accountability.
Yes. The software doesn't care what your actual job title is or what your salary is. The moment you log in with those privileges, it watches your every single keystroke.
And if you accidentally delete a critical file while just trying to fix that printer, the system doesn't say, oh, well, they're just the IT intern.
No, definitely not.
It treats you with the exact same severity as if the chief technology officer deliberately sabotaged the servers. I mean, the physics of the system dictate the punishment, regardless of your actual power in the company.
Precisely. Today, we are stepping out of the digital realm and into the world of criminal law, specifically the legal framework governing crimes committed by public officers.
Right, looking at Title 7 of the Revised Penal Code.
Yep, Title 7. Our focus is on how the law defines exactly who is held accountable to the public and the incredibly strict mechanisms by which they are judged.
And it's a fascinating landscape because it constantly challenges our everyday intuition about, well, fairness and hierarchy.
It really does. So the central question we are debating today is this: does the expansive legal definition of a public officer and the strict mechanisms of accountability, such as the presumption of guilt and malversation, serve as a necessary and robust shield for public trust?
Or conversely, does this framework cast an overly broad net that unjustly criminalizes temporary workers and, mere administrative oversights?
Exactly. I represent the view that focusing strictly on the functional nature of the duty rather than formal titles is an essential, rigorous framework. It's really the only way to effectively protect government integrity from exploitation.
And I take the position that while protecting the public purse is an undeniably laudable goal, this framework is structurally overbroad. I believe it creates a legally perilous environment by relying on harsh legal fictions and extending severe public liability to individuals who entirely lack formal, systemic power.
Well, let's dive right into the core of this, the definition of a public officer. To understand how this works, we have to look at Article 203 of the Revised Penal Code.
The foundational text here, yeah.
Right. This article essentially says that if you are taking part in the performance of public functions, you are a public officer. It explicitly makes rank or class completely immaterial.
Let me pause you there because I want to make sure we're completely clear on what immaterial means in this context. We aren't just talking about the difference between a mid-level manager and a senior director, right?
Oh, not at all. We are talking about the difference between an elected official and a day laborer.
Right.
There is a landmark piece of jurisprudence, Miniego versus People, which explicitly established that under Article 203, there is no distinction whatsoever between an officer and an employee.
Wow.
By extending this immense accountability to even temporary laborers the moment they perform public duties, the law constructs an impenetrable wall.
But what does that wall actually look like in practice? Because on paper, sure, impenetrable wall. But practically?
Practically, it looks like a system where no one can exploit legal technicalities. Let's make this concrete. Consider the case of People versus Belongao.
Ah, the laborer case?
Exactly. This involves a temporary laborer. Now, under normal, everyday circumstances, a laborer is definitively not a public officer. But let's say the office is incredibly short-staffed one afternoon, and someone hands this laborer a stack of money orders and says, "Hey, I need you to sort and file these."
Right, a totally mundane task.
The moment that laborer touches those money orders, they are performing a public function. The mantle of a public officer instantly falls upon them.
A mantle they neither asked for nor have the structural compensation or training to bear. It's wild when you think about it.
I see why you think that, but let me give you a different perspective on why that is necessary. Think about the underlying mechanism of vulnerability here.
Okay.
If the temporary laborer is sorting the money orders, the state's money is physically in their hands. The risk to the public is identical whether those hands belong to a temporary minimum wage hire or the head of the department.
I mean, the physical risk, sure.
Right. If the laborer slips a money order into their pocket, the damage to the institution is exactly the same. The law rightly follows the function, not the badge. Because the public's exposure to risk is the same, the standard of accountability must be the same.
Well, I come at it from a different way. Your justification assumes that the temporary laborer has the same agency and the same systemic support as the department head. And that's where I see a glaring conceptual contradiction in the law's architecture.
What do you mean by contradiction?
Well, the legal framework itself acknowledges that a laborer lacks standing. It explicitly states, citing both Maniego and another case, People versus Paloma, that one appointed as laborer is not a public officer.
Right, but by default.
By default, exactly. The law knows what a laborer is, yet it allows a mere temporary performance of a task they probably couldn't refuse without getting fired, by the way, to instantly override this foundational protection.
But they're still performing the duty.
But you're taking an emergency helper in the Bureau of Treasury, someone with zero policymaking authority, and holding them to the exact same penal standards for malfeasance as an elected official. Holding a temporary helper strictly liable ignores the reality that they are at the mercy of the systems built by those actually in power.
That's an interesting point, though I would frame it differently. The strictness applied to that temporary helper isn't a glitch in the system, it's a practical inevitability of governing.
A harsh inevitability?
Maybe, but inevitable. Which brings us to the most controversial, but in my view, the most necessary mechanism of this entire framework. Article 217, the presumption of malversation.
Yes, this is the heavy artillery of the Penal Code. Before we get into the weeds, let's define malversation for our listeners.
Good idea.
It isn't just a fancy, archaic word for ordinary theft. In this context, it's the specific crime of a public official misappropriating public funds or property that has been entrusted to them.
Exactly. And the mechanism the state uses to prosecute this is ruthless. In the case of de Guzman versus People, it was clearly established that a conviction for malversation can be had even in the complete absence of direct evidence of misappropriation.
Wait, let's unpack that. You're saying the state doesn't have to prove you actually took the money?
Direct evidence isn't required. All that is required is a shortage of accounts that the officer cannot satisfactorily explain. And I argue this isn't a malicious overreach. It's an empirical necessity.
How so?
Think about why the state does this. Because the state is vast. It spans thousands of islands, countless municipalities, tens of thousands of barangays. It physically cannot put an auditor in every room or install a camera over the shoulder of every single clerk or temporary worker handling centavos and pesos.
True, the logistics are impossible.
Right. The only way a bureaucracy of that scale can protect itself from being bled dry by a million tiny paper cuts is to demand absolute, perfect custody of the funds.
I understand the logistical nightmare the state faces. I really do. But the cost of that administrative convenience is staggering. You're replacing the rigorous legal mechanism of establishing criminal intent with an assumption of guilt.
It's a presumption based on a failure to account.
Let's look at the mechanics of U.S. versus Kalingo. The presumption of malversation arises upon the mere failure to have public funds duly forthcoming upon demand. Do you realize how legally perilous that is for a normal person?
I'd say it establishes a baseline of supreme vigilance.
No. It creates a regime of strict liability out of what could very well be a simple accounting error.
Well,
If an auditor walks into a provincial office, asks to see the ledger, and you're 10 pesos short, boom, the law instantly assumes you stole it. You could have made a mathematical error, misplaced the decimal point, or been the victim of a systemic failure in the software you were forced to use. The framework equates mathematical incompetence or disorganization with deliberate malicious theft.
it equates them in outcome because the outcome for the state is the same. The money is gone.
But intent.
Furthermore, when malversation is committed through negligence, meaning you didn't mean to lose the money, but you were careless, the law explicitly notes that good faith or a lack of criminal intent is not a defense. The law demands a standard of care commensurate with the occasion. If you hold the public purse, the state demands perfection.
I'm sorry, but I just don't buy that. Let me tell you why. The harshness of this rule reaches an almost absurd, Kafkaesque level when you look at how the law treats restitution.
You're referring to the Filiano Doctrine.
Exactly. Let me tell you a story about how harsh this is based on U.S. versus Filiano. Imagine you were that clerk. You misplace some funds. You realize your ledger is short. You panic.
A very human reaction.
You go home, you empty your own personal savings, and you bring the money back the very next morning to cover the gap. You fixed it, right?
You replace the missing funds, yes.
But under Filiano, the return of those funds is merely a mitigating circumstance. It is not an exempting one. You are still a criminal.
Because the crime was already consummated.
The only way there is no liability for malversation is if the shortage is paid by the public officer from their own pocket the very moment the shortage is discovered by the auditor. If you need 24 hours to run to the bank to fix your honest mistake, you are guilty of malversation. This proves the framework punishes the sheer inability to balance a ledger or the lack of personal funds to immediately cover a gap as harshly as a deliberate embezzlement. It traps the honest but disorganized worker.
I acknowledge the severity of the Feliciano doctrine. It is undeniably harsh, but I'm not convinced by that line of reasoning because it completely ignores the deep definitional precision built into the law to protect those very workers from arbitrary punishment. The law does not just blindly attack anyone standing near a vault.
It certainly feels blind if intent doesn't matter.
But control matters. Let's break down the mechanics of U.S. versus Wickersham. This is a crucial distinction. In Wickersham, you have a clerk who was entrusted with the combination and the key to a safe.
Okay.
You would think, under your interpretation of this broad net, that if money went missing from that safe, he would be presumed guilty of malversation, right?
By your earlier logic of functional duty, yes, he's holding the key.
But the court ruled he was guilty of theft, not malversation. Why? Because although he had the key, he had no actual control over the contents of the safe.
Interesting.
He wasn't authorized to open it except by the express direction of another senior officer. He was a custodian of the lock, not the money. The law clearly differentiates based on who has the actual functional authority to part with the physical possession of the property. The standard of care is entirely commensurate with the actual authority granted. It is not a blind sweep.
That distinction in Wickersham actually highlights my exact concern. It proves that the line between being a mere thief, which has one set of penalties, and being a highly penalized public officer facing malversation charges rests on highly subjective, incredibly thin legal fictions regarding control. A key but no combination? A combination but no authority?
It's nuanced, sure.
And this brings us to the most concerning aspect of the entire framework. How this liability bleeds out of the government entirely and infects the private sphere.
See, I actually view that bleed as the framework's most sophisticated feature. Let's be realistic. Corruption, the misappropriation of funds, the hiding of assets, these things don't happen in a vacuum.
Right.
A corrupt government ecosystem requires private accomplices. The law smartly expands liability to private individuals under Articles 222 and 225.
So explain how a private citizen gets caught in this net.
It's quite logical. If a private citizen acts in conspiracy with an accountable public officer, they are legally treated as public officers for the purpose of the crime. Furthermore, if the state seizes property and asks a private citizen to act as an administrator of that seized property, they fall under the same rules.
Okay.
Or under Article 225, if a private person is entrusted with the conveyance or custody of a prisoner, they can be held liable for their escape. You cannot outsource government duties to private citizens and expect the accountability to vanish into thin air. The liability must follow the public interest, even if the hands holding it are private.
Well, that's a compelling argument, but have you considered that this is exactly where the framework completely loses its conceptual anchor? Let's look at the jurisprudence of U.S. versus Restrillo.
Yes, the judicial deposit case.
Yes. Let's translate this for the audience, because the terms can get dense. What is a judicial deposit, or an attachment? Let's say two private citizens are suing each other over a piece of heavy machinery, maybe a tractor.
A classic civil dispute.
Right. The court steps in and says, we're freezing this asset. We are putting an attachment on it. Nobody can sell it until the lawsuit is over.
Standard legal procedure to preserve the asset.
Right. But the court needs somewhere to put the tractor, so they hand it to a third-party private citizen to hold onto in their garage. They become a private depository. Now, in Rostrillo, this private individual misuses the property. Do you know what happens to them?
They are subjected to the specific enhanced penalties of malversation.
Exactly. But why? The property ultimately belongs to private individuals. It's two neighbors fighting over a tractor. But if the guy holding it misappropriates it, he isn't just charged with standard swindling or estafa, as it's known in the penal code.
No, he's hit with malversation.
He is hit with the hammer of malversation, a crime designed for corrupt politicians. Do you see what that reveals?
I mean, it reveals that the property was under the authority of the state.
It proves that this entire framework is ultimately obsessed with protecting state control over assets rather than strictly policing the integrity of the public office itself. The state is utilizing the severe penalties designed to protect the sacred trust of public office merely to enforce compliance with its own administrative paperwork. It captures private citizens in a web of presumed guilt just to assert state dominance.
I don't see it as state dominance. I see it as the preservation of systemic integrity. If the state attaches a piece of property, even a private tractor, it is making a promise to the judicial system that those assets are frozen and secure. The court's authority is now physically manifested in that tractor.
But the punishment,
If the private administrator violates that trust, they are violating the state's promise. They are degrading the power of the court. Therefore, they must face the state's penalty. The logic holds up perfectly.
it holds up mechanically, sure, but ethically and proportionally, it's a massive distortion of what a public officer is supposed to mean.
Well, what we've explored today reveals two highly divergent views of the exact same penal mechanisms. From my perspective, a rigid functional definition of public duties combined with strict presumptions of liability is the only empirical way to prevent the state apparatus from being exploited.
Right.
If we allow formal titles, employment status, or private citizenship to dictate accountability, we create loopholes. The strictness, the fact that the law demands perfection from anyone touching public funds, is the very feature that keeps the system intact.
And to summarize my position, while the goal of protecting government integrity is undeniably noble, the actual mechanics of this framework stretch the definition of a public officer far past its logical breaking point.
By pulling in temporary workers and private citizens.
Exactly. By utilizing legal fictions like the presumption of guilt upon mere accounting shortages, and by bleeding this liability into the private sphere, the law creates an environment of extreme penal peril. It prioritizes the flawless accounting of state assets over the proportional agency of the individuals, often temporary, low-level workers, navigating the system.
Yet, despite our profound disagreement on the fairness of the application, I think we both clearly acknowledge one fundamental truth about the Revised Penal Code. It prioritizes the nature of the duty performed above the formal title of the individual involved. The function truly dictates the law.
We definitely agree on that mechanism. The law cares about what you're doing, not what your badge says. Where we remain entirely at odds is whether this functional approach represents a triumph of rigorous public accountability or a dangerous overreach of penal power that crushes the little guy.
And this tension between state control and individual fairness is everywhere in this area of law. For those looking to delve deeper into how the state draws these fine lines of power, the intricate rules surrounding infidelity in the custody of documents under Articles 226 through 228 and the nuanced liabilities of prisoner evasion offer incredible avenues to explore this exact dynamic further.
Absolutely. The mechanics of who gets punished when a sensitive document is concealed or when a prisoner simply walks away from a private guard rely on these exact same underlying philosophies of custody, control, and functional duty.
Metaphor we started with.
The admin writes,
Exactly. We have to ask ourselves, when building a system of justice, is it safer to engineer a network where every single user who touches a sensitive file is treated with the maximum possible suspicion and accountability?
or does that immense, unyielding pressure guarantee that the most vulnerable temporary users will eventually be crushed by mistakes that aren't truly malicious?
We'll leave that for you to decide.